Okay. All right. Good morning. My name is Justice Barnes. I'm a judge in the province of Ontario, Canada, and I'm chair of the Association of Justice and Treatment Professionals. On behalf of that association, which is sponsoring this 4-day webinar conference, welcome. Before we begin, it is appropriate to make a solemn acknowledgement. And as more and more people enter our virtual courtroom to begin our proceedings for today, I'm going to call on the host for today, Abdul Glazy, to do the land acknowledgement.
Yeah, so first of all, thank you, Justice Barnes, for this opportunity. I'm just going to kind of do a bit of a land acknowledgement. Again, I am from Toronto, so I'm going to do the land acknowledgement from Toronto, and I do recognize that many of you come from other indigenous land. So here's the Toronto acknowledgement. So Toronto is a dish with one spoon territory. The dish with one spoon is a treaty between the Anishinaabe, the Mississaugas, and the Haudenosaunee that bound and share the territory and protect the land. Subsequent indigenous nations, peoples, Europeans, and all newcomers has been invited into this territory in the spirit of peace and friendship. I also personally want to go a little bit beyond just reading this. I think I do acknowledge that I am a settler on this land. I do acknowledge that this land is a stolen land. And I do acknowledge that I have certain responsibilities towards this land, and that I think part of the purpose of this particular conference is also to recognize, you know, the marginalized communities and how institutions could better treat our indigenous and marginalized communities. So I think it's in that spirit, I think, that we are having this particular conference, and I would want to kind of acknowledge, and I want to kind of be an ally, and then I'm hoping that most of you who are joining in here kind of come in that spirit. So thank you, Justice Barnes, and back to you for the introduction.
You know, 30 years ago, I was almost 30 years ago, and actually makes me feel a bit old, but 30 years ago, I was a very young lawyer. You know, I just got out of law school. I was working with the Public Prosecution Service of Canada. And I was an ambitious young man, and was interested in doing very complicated legal matters. And one day I was called in by my superiors and said, listen, there's a particular judge somewhere at Old City Hall who wanted to integrate treatment into the court system because he had noticed that drug-addicted offenders were going in and out of the court system. Sentences were not making a difference. I was not too thrilled to get that assignment. I more or less figured that it was the end of my career. I figured I was not going to allow myself to be involved in something like that. But I was asked to do it, so I started to do it. And the impacts on me as a human being were amazing. I mean, you know, to see human beings who had lost everything, people who had been marginalized, people who had gone through trauma, suffered addiction, discrimination, mental illness, all that sort of thing. To see them go through a collaborative program between justice and treatment, and see them change their lives was amazing. So 30 years ago, we formed Canada's first therapeutic treatment and therapeutic court called the Drug Treatment Court. And over that period of time, for several years, Paul Bentley and I, who was the guy who came up with the idea, he was a judge at the time, and unfortunately he passed on, and a number of other partners traveled the world talking about what we had found and talking about this holy grail that was going to solve all the world's problems. And we're excited because in those days it was revolutionary that the treatment will actually be brought into the courtroom in such a close fashion. Well, as we traveled the world, the more I spoke, the more I realized I had more to learn. The more I spoke, the more I realized, the more I gave and went to speak as an expert, the more I realized that people had a lot to teach me. And as the years went by, I began to realize that those of us who work in treatment and therapeutic courts, are passionate about what is done, because you see, those courts have a number of characteristics. You're going to find that those courts, no matter what they are called, in general, have a partnership between treatment and therapy of some sort. You're going to find that they're going to involve some multidisciplinary partnerships of legal and non-legal people working together, trying to achieve the holistic rehabilitation of persons who go to the program. You're going to find that they're going to have case management processes, and there may be incentives and accountability structures in place. People who finish it, may not have custodial dispositions, but it's all about trying to address the root cause of these issues. And you're going to find that these courts go by all kinds of names: domestic violence courts, drug treatment courts, mental health courts, GLADU courts, family protection courts, community courts, wellness courts, all kinds of different names, but the objective is the same. I had a very great interest in learning. And I began to realize that different professions has a lot to teach each other, because different professions and people from different walks of life doing different things learn different things about the individual, about society, because all of this stuff is a product of so many things in human beings' lives. And I began to realize the importance of things like evaluation to see how programs are functioning, what is working. You see, I'll tell you, there was a time when we started this program in my youth, not knowing too much. The program I was involved in was focused on addiction, and not knowing too much about addiction. I thought I did. You know something? You do not know what you don't know. All right. So we figured we'd come up with the Holy Grail. We had brought these people into the treatment, into the courtroom. So we have solved the problems. We are going to get into treatment. We're going to teach people how to get treatment, and they're going to be well. Well, we didn't really understand addiction. See, one of the things that we used to do is the judge will be the nice person. If a person, for example, had a relapse, the judge will be a nice person who speaks to the person involved and so on and so forth. And then he'll turn to me, Mr. Barnes, do you have anything to say? And that was my chance to just go like crazy, show that I was upset, trying to get this person to not continue to relapse. Well, over the years, I began to realize that I did not understand trauma. I did not understand that in fact, people have experienced trauma. And that when we got together and gave those big speeches to people, in fact, we were re-traumatizing them. You see, that's when I realized that it was important to learn. And that's why you'll find that in one of the sessions, we talk about trauma and the impacts of trauma, because we have lots to learn. There were things 30 years ago that we thought were great. Now that we learn about the impacts of trauma, we know to do better. And also you see that there will be some sessions on evaluation, because you see, one of the great things about this is this: the people who do this work are passionate. They are passionate because they can see the redemption of the human spirit. They see people get better. But with that passion, we also become wedded in our beliefs. We have certain beliefs that certain things work. Well, that is why evaluation comes in. Because when you do evaluation of your programs, you tend to try to find out what is working and not working. For example, many years ago, we used to believe that speech I was giving was what was getting people to change their lives. Well, our evaluation showed that no, I was totally wrong. That speech was making them worse. What was making them better was when I gave them encouragement and support, and when I showed that I understood as a prosecutor. See, this is an example of how evaluation makes us better. And so that is the reason why we have sessions on evaluation. As time goes on, things are changing. Cannabis is legal. There are certain provinces, or for example, in British Columbia, that possession offenses are not being addressed. In fact, in general terms, there are instructions that have been put to various services such that simple arresting or prosecuting for simple possession of drugs is not really the way to go these days. Well, the question is that as these things are happening, what impact is it having on various programs? We have a lot to learn. And that's why the sessions is, okay, you know, how do we adjust? Are these changes having an impact? What type of impact are they having? There's a long debate within the treatment community on issues of harm reduction and whether that is the way to go, or abstinence, whether that's the way to go. Well, you know, why is it that certain people seem to respond possibly to harm reduction? Why is it that certain people seem to respond good to abstinence? What is the way forward? Well, we are having that is why we have these conferences. Those are the things that we learn. I remember many years ago, when we started the first therapeutic court in Canada, we used to have young people, and we used to treat them the same way as adults, like we hold them accountable. After all, you got to hold them accountable when, you know, and we were failing miserably. Well, as we got some more training, we came to realize that young people, adolescents, you know, their executive functioning frontal lobe is not as well developed as the emotional centers in their brain. And so you had to deal with them differently, you know. And in fact, I remember some years ago as a judge, a circumstance in which I was presiding as a judge in the provincial court, and I had a reputation for dealing with young people. So a couple, you know, came in with their child. The Crown had permitted them to do, and defense came in with a child, and the family was waiting for me to now hold the child accountable. I was going to now start to tell the child what a horrible thing he's done, and so on and so forth. They were waiting for me to do that because you gotta, maybe coming from a judge, it to make a difference. Well, instead of doing that, I began to talk to the child about what they like, what they are interested in, who their friends are, you know, trying to understand what made them tick. I looked down, I could see that parents were not too happy with me, but they were respectful. They didn't say too much, you know, you know, and stuff. It's because I had just learned about brain development with young people. And I learned that it was important for me to come to understand what was important to them and use that to try and achieve them to start to develop positive reinforcement. It's something I learned. And that's the reason why you find that we have sessions today, joined the program on youth and why youth are treated differently. You know, one of the things also that also happened over the years is that we began to get excited when we started these therapeutic courts, right? You know, but you know, not everybody is able to go into these therapeutic courts. Not everybody goes through it. And we began to realize as time goes on is that how do we find a way to import some of these therapeutic justice and treatment partnership strategies into regular court processes, right? You know, and so you see that we have sessions here that have got nothing to do with therapeutic courts specifically. We are dealing with things like how do you deal with this thing in bail in general or in sentencing in general. Okay. Another thing too that struck me is this. When I started 30 years ago as a prosecutor dealing with the very first therapeutic court in Canada, I started to screen, because the prosecutor determines who comes into the program. I began to screen people going to the program with gusto, right? And I realized that the people who I was screening into the program did not reflect the population that we're looking for in terms of their racial or ethnic or gender or any kind of diversity. Why was that? I just did not understand. Right? Why did it look some people were being excluded? Were they not applying? Of course they were. Then I began to realize that we all go through Canada, and I should know this. We walk through the same streets, we go to the same places. Well, I mean, at least the same shops in general terms, but we don't experience the world the same because of differences in the way people are treated. And so I began to realize that when I looked at a person's criminal record, for example, the requirement was the person was supposed to be nonviolent. So if I was to treat, so in general terms, that meant that I will simply look at the number of convictions they have and make a decision. Well, I missed the point. There were certain people who were marginalized to the extent that assault, certain types of convictions will be on their record. What was more important was not the number of convictions. What was more important was why the conviction happened. What did they do? Right? So, and once I began to realize that these were just minor activities. A little push, a little shove here. Things that will occur as part of their marginalization on a regular basis. You see, that's when I began to realize that understanding the differences in our world and the way we go through, understanding the impacts of gender discrimination, racial discrimination, understanding the impacts of trauma, brain injury, disease, understanding all of those things helped me be better because it helped me make decisions in a more informed way. And we began to reach our target population. And that's the reason why you see topics on brain injury, you see topics on racism and so on and so forth. In fact, brain injury is very interesting because, I remember being a scenario whereby there was somebody who was functioning well dressed, but he has such a lousy criminal record. Didn't seem to understand why. Well, you began after some digging around. The person had brain injury. It affected their memory, even though they presented well. They didn't, because of the injury and the impacts of the injury, right? They were not functioning appropriately. An example of the fact that looks can be deceiving. Fetal alcohol syndrome. These are all issues. The more we know, the better we get. And so I want to wrap up here by just extending gratitude, right? Gratitude. Today, over the next 4 days, we are going to hear people talk about, there'll be at least some 34, 35 topics. We're going to hear from 65 experts. And we thank them very much for giving up their time. Over the last 2 years, we've covered over 120 topics. We've heard from more than 200 experts, and we are grateful. One of the things that we are also doing, that we realize as we go through is, so we are experts, but something, people with lived experience have to be part of the expertise to help us get better. So you see in the agenda, for the first time, we have a judge and a person of lived experience getting together to do a session on what works, what doesn't work. We have a panel of people who are persons of lived experience. We have a host in one of the days who's a lived experience. We're beginning to realize that we need to include people with lived experience to get better. Ladies and gentlemen, it is with great pleasure that at this point, I recognize Abdul Gilze. He has over 35 years of social work experience working with the most marginalized communities in our society, in our city, it is Toronto. People experiencing substance use, mental health, and homelessness. He uses this knowledge to teach social work at both the graduate and undergraduate levels at various universities such as the Toronto Metropolitan University and the University of Windsor, teaching both graduate and undergraduate students. In addition, Abdul also teaches, Abdul also teaches bridging courses to the internationally trained professional social worker. Currently, he is in his PhD program at the Department of Social Justice Education at Ontario Institute for Studies in Education at OISE. Abdul is in charge. He is your host for the rest of the day. Abdul, thank you so much for doing this. And it's been a pleasure speaking to you.
Yeah.
Over to you, Abdul.
Thank you, Justice Barnes, for that warm, excellent introduction. I could not have done this myself. Thank you, and thank you also, I think, for summarizing and kind of setting the stage for the rest of the day. So without further ado, I want to introduce to you Susan Reed, our next speaker. Susan Reed has been a Crown Counsel with the Crown Law Office, Criminal at Ministry of Attorney General for Ontario for almost 32 years. She has appeared at all levels of the court. Currently, her practice focuses on criminal appeals in the Ontario Court of Appeal and the Supreme Court of Canada. She was a Deputy Director with the Crown Law Office for almost 20 years before choosing to return to counsel work. Susan has taught appellate advocacy to the Crown Counsel in Ontario and to war crimes prosecutors in The Hague, that's of course the Netherlands. She also regularly lectures on a range of criminal law advocacy subjects. Susan became involved in the study of mental health, drug treatment courts, through her work with the supporting the Assistant Deputy Attorney General and the Deputy General of Ontario as a member of the Justice Efficiency Access to the Justice System Committee. This defense bar and the police services and other deputy ministers from across Canada. So Susan has led a team of 11 counsel students and the staff in the creation of the report entitled The Therapeutic Courts in Canada, a jurisdictional scan of the mental health and drug treatment court, which was completed in September of 2021. So Susan, thank you. The floor is yours.
Thank you very much for that introduction. I'm going to share my screen because I've got a PowerPoint that hopefully will make it easier to follow along. Can you see the screen?
Oh, yes, Susan,
okay, great.
We can.
Okay, that's the cover of the report that I'm here to go through with you. This is, I would call this 30,000 feet tour, macro tour of this very complex area. I think it's actually quite a good introduction to set the stage for all of the people who are going to come after me, where they're going to get into the much more, I think, important details. But this is in my opinion, it's a really valuable resource. It's really the first of its kind to integrate all of this information in one place. The committee itself, which is the Steering Committee on Justice Efficiencies and Access to Criminal Justice, and let me just flip my, there we go. That's a national committee. It's a very high-level committee with deputy ministers, senior members of the judiciary, the bar, and police representatives. So it's a very high-level committee where there's a discussion of issues that are affecting the criminal justice system. And often from that committee will come recommendations to the federal government for changes, which in the past have come to pass. Issues such as bail and major case management, for example. So the committee decided they wanted to look at therapeutic courts and ask what might appear to be a fairly straightforward question: are they working, and what are the best practices? And so a subcommittee was formed, and I, in support of that, led this study. The focus on this, while the question was about therapeutic courts, the focus was on mental health and drug treatment, because we needed to focus our energies, notwithstanding that there are all kinds of other types of therapeutic courts. A lot of the principles that you're going to hear about today, I think, are well applied in those other courts. So the next question is, how did we gather the information? We interviewed over 80 professionals from across Canada. And this was during the pandemic, of course. So we were using virtual methods to do that, sometimes in group interviews. So we interviewed judges, lawyers, both Crown and defense, and the treatment providers. The people we did not interview, and I want to note this because I think it's an important omission, which you're going to hear about Fortunately, we could not include, given our time constraints, but people with lived experience. That is, the people who have participated in these courts were not included in the study. And I think that is essential information. This is a cross-discipline report, though, speaking from all dimensions of the professionals who work in these courts. The consensus, spoiler alert, is that these courts are working. They're making a difference. They are socially and fiscally responsible. Various kinds of measurements, but reports that they are reducing the rate of reoffending. They're improving the quality of life for the people who are going through these courts. They are enhancing public safety. They're reducing the demand on emergency health services, policing, and courts, which of course has cost savings. There are a number of evaluations that you will see, and I've referenced them there in the slide, from across Canada, a number of courts who've actually been able to do evaluations, and they're referred to in the study. There were also differences of opinion, but really only 4. There was, for the most part, consensus amongst all of these professionals across the country. The 4 areas of difference were, first of all, and you've heard about this from drug treatment court perspective, is it abstinence or harm reduction? What's the goal here? And quite a strong difference of opinion about that. The second big difference of opinion was the effectiveness of virtual court appearances. We had a chance to test that out during COVID. And while they are efficient and they're faster and they're easier for people who are far away, their home base is a distance from the court. What they also lack, though, is that connection that is achieved through these courts. And there's a quote from one of the people who were interviewed about what's lost through the virtual court appearance. Of course, there's also, and we'll speak about this in a moment, but the difference in sort of equity access to the technology that you need for that virtual appearance. The third difference of opinion, eligibility criteria. Should it be expanded in each court and in drug treatment courts to examine individual risk rather than having arbitrary exclusion of specific offenses? And the fourth and last difference of opinion was about guilty pleas. Do we need them? Are they necessary to gain access to these programs, or are they a barrier? I want to pause and just note I've lost my page here. I just want to pause and note the optimism, the dedication, and the professionalism that I certainly observed doing this project. It was really quite impressive when we spoke, without exception. Every team member that we spoke to was passionate, as Justice Barnes spoke about earlier, about the work that they do. And they were passionate about the differences that they were making in people's lives. And I've got some quotes there on the slide of the comments people have made. The first quote is from a judge who was instrumental in establishing a wellness court in Ontario. And her description of how these courts bring out the humanity of the process, which is one of its joys. You walk away feeling that today we made the world better. I think that's really key, and we have to hold on to that thought. And I just want to acknowledge that for everyone who's watching today, who is involved in these courts. Really, a huge credit to you for your passion, your optimism, your dedication, and your professionalism. So to return to the report, it has 7 main sections. The highlighted ones are the ones I'm going to quickly try to go through with you today. There is a fairly detailed summary at the beginning, which really covers everything you might want to know and to help you know where to go in the report if you want to find something specifically. There are appendices. There are some 20 appendices in total for each province or territory, or in the case of Ontario, broken down into regions because we have so many of them in Ontario. It sets out the unique features of the mental health and drug treatment courts in those jurisdictions at the time of the report. It includes hyperlinks to all of the documents if they were available by hyperlink, all the materials gathered, templates, assessments, manuals, etc., for those jurisdictions. So it's a very useful resource. And then the source list also is a list of all of the materials that we gathered, and many of them are hyperlinked. So let's turn to the barriers that we identified. There were essentially 9, to group them, barriers. The first, of course, insufficient program funding. That's not going to be news to anyone who works in this area. What was interesting to note was drug treatment courts, of course, often have federal funding, not all, but many, if they meet certain criteria. The mental health courts, for the most part, do not have dedicated funding. There is no standard approach to that. It is, of course, mental health is a provincial jurisdiction, but it often is, courts are scraped away from the budgets of the existing court budgets and in-kind services from other departments. But that means that you've got challenges with staffing, and you may not be able to staff program managers, data collection expertise, and things like that. So obviously, insufficient program funding is a significant barrier. Lack of stable housing, critical, absolutely critical. Without stable housing, participants can't find stability, but they're also continue to be exposed to the environment that undermines their treatment. Inconsistent justice staffing, again, very key. I think this is a message that we need to get to our justice partners who are making decisions about staffing, both the judges and the crowns, for example, in these courts. What makes these courts work are the relationships that are created, not just between the team members, which is important, but the relationships that are created with the participants who are coming through these courts. We need to build consistency in trust and accountability, and we can only do that with consistency in staffing. So that means a dedicated judge or team of judges, depending on the size of the jurisdiction, a dedicated prosecution team, and not simply rotating people through. Inconsistent and insufficient support services. That's all the support and treatment services that support these courts. There's a long list in the report of all the kinds of community services and therapeutic supports that some courts have found effective, but others have not had access to. The problem is, of course, there may not be a wait list for court, but there's a wait list for the programming. And of course, with that, you're going to seriously undermine the effectiveness. This is a particularly acute problem in the North, where participants often have to go south to get into any residential treatment program. And then that has all kinds of implications for culturally appropriate programming and distancing from family and other supports. Inflexible or narrow eligibility criteria. Again, we spoke about that earlier. Arbitrary offenses preventing someone from being able to have access, or, for example, the history of violence or gang affiliations automatically excluding people. That has had the effect of excluding a lot of racialized participants. And we know racialized members of our society have historically been arrested more often or incarcerated more often. That may set them up to be less eligible for these programs. And we have to ask the question whether this is perpetuating systemic racism. Similarly, excluding specific offenses. There are therapeutic courts that will take people charged with manslaughter. Other courts, absolutely not. So, interesting question about how we might approach that. Lack of public awareness. There's no information about some of these courts available, no online presence. When the public don't know about these courts, they don't seek them out, and that makes the courts less accessible. This was a problem noted particularly in racialized communities, this lack of knowledge. Divergent views about best practices between legal and non-legal team members. Team members, of course, come from very different backgrounds: law, mental health or health treatment, and policing. So they have different, sometimes come in with different priorities, different experiences. So we need to find a way to bring them together. And as Justice Barnes spoke about, how much we can learn from each other. And one way that we observed was cross-training, where team members train together. The requirement of a guilty plea, again, I spoke about that as an area of lack of consensus. but it is seen as a barrier, particularly in a mental health context where cognitive issues may impair a participant's ability to remember the incident or even understand that their behavior is wrong. The last is the impact of COVID-19 and that loss of connection, when I spoke about that earlier. How difficult that was, how it shut down courts for a long time before they got back up and running. And then how much that virtual connection leads to a loss of connection. The difficulty in achieving accountability, which is often part of the successful process in these courts. That is, the participant feels that they have some accountability because the people are listening and they care about whether they're going to succeed. Also, the need for bail to happen in these courts, not from jails or not from somewhere remotely, because then court workers aren't able to see them. So the best practices I'm listing here, I'm not going to go through all of them because you're going to hear repetition when I talk about recommendations, but these are the kinds of best practices that we gathered up and have identified in the report. There are 16 of them. And I'm sure you're going to hear a lot about these in the next 4 days of how many jurisdictions are doing these various things. And these are the remaining 16 best practices. Something that was very exciting that we found was the new and evolving therapeutic courts. So cultural trauma programming, which was happening in Nova Scotia and perhaps elsewhere now, started in 2016. And that's where you've got people who are not, who are charged with offense, but don't have a formal mental health diagnosis, but have suffered trauma due to race, ethnicity, marginalization, or abuse. So what's called a cultural impact study and cultural trauma letters are prepared by clinicians. This cultural impact guide has been created in Nova Scotia to assist with that. And they are preparing these letters. They're not unlike a GLADU report for Indigenous offenders, but they're focusing on cultural trauma. The other exciting evolution is the Fetal Alcohol Spectrum Disorder Court. Manitoba is the first jurisdiction to create such a court. And I think you're going to be hearing about that specifically on Wednesday. So the next section of the report deals with measurement and evaluation. And this has always been a kind of a bedeviling challenge. We all know, or we believe, these courts are fiscally and socially responsible. And you heard about me saying that at the beginning. The challenge, and Justice Barnes noted that, is the importance of how do we measure these courts. There are some best practices that we gathered because there are courts who have measured their success or measured their programs. Some of the best practices that we identified were make an evaluation plan as part of your implementation of the court. So if you've already got a therapeutic court going, you can do it, but it's more challenging to retrofit evaluation if you hadn't built it in the beginning. Include data recording and tracking at the implementation stage, because it's data that's going to support your measurement. Create participant exit interviews or surveys. Let's hear about that lived experience. It will inform the decisions that you make. Consider partnerships with local academic institutions and qualified researchers who can help you with that measurement. Perhaps that, you don't have to pay for the Cadillac version if your budget won't permit. And include recommendations as part of the evaluation process so that you can build on your strengths. So the question, though, for measuring is, what does success look like? And there's a quote there from a person we interviewed about what they see success looking like, the idea of someone being open to change. So you have to ask the question, what are you measuring? Is it recidivism or harm reduction? And if it's recidivism, what does that mean? Is it fewer arrests, fewer charges, fewer convictions? Are you measuring greater stability in the community, emergency room visits, 911 calls, abstinence versus substance abuse? No, have you succeeded if someone is reducing the amount of a substance they're using? Are you saving money? These are all ways to measure success. Some of them are quantitative, some of them are qualitative, and will require different tools. So the challenge that you face then is your data collection. How are you going to get the data you need to achieve the measurement that you're seeking? Hospitalizations and ER visits are health data. Police resources are justice sector data. The incidence of property crime perhaps going down, court and prosecution systems data, that kind of thing. Those are all the kinds of things that you may want to access. So then you have to start thinking about privacy protocols and how are we going to get access to this information. So there are 12 key recommendations that I'm going to go through, and they reflect the best practices that I had alluded to earlier. So the first is to share this report. So when we prepared the report, we asked the Justice Efficiencies Committee to please make this report public, which they could choose not to. But the committee decided yes, they would, and it's now published on the website of the International Center for Criminal Law Reform and Criminal Justice Policy. And the link is in this slide. And I believe this PowerPoint is going to be available to people afterwards. So you can click on the link and find the report there. And then we can share it and share it at conferences like this, which is by word of mouth, I think is also in a really important way to get the information out. The second recommendation we made was to create national, provincial, and regional umbrella advisory committees, which can support and coordinate resources so that people aren't reinventing the wheel over and over again. They can share from what others have learned and contribute what they already know. So we have committees at both the macro and the micro level to really start to build something and from what everyone else has learned. I understand that there are now discussions underway between the provinces and the federal government to try to start to create that kind of advisory committee. I don't know that it's gone any further than discussions, but that is underway. Another recommendation that we made was to consider integrating the drug and mental health treatment courts into a concurrent disorders courts. It makes so much sense, given that mental health and addiction often go hand in hand. They are not sort of separate boxes. They obviously overlap. The benefit is the coordination and sharing of resources. Your treatment team members, can work together. There are jurisdictions that are doing that. I've put some examples in the slide where they are doing concurrent disorder courts, and you can see that in the report. And make no mistake, that doesn't mean that you have one courtroom that does everything or only does it one way, because of course your participants with needing drug treatment and your mental health participants may be very different in their needs and how they are going to experience that courtroom and what would be the right way to do that. So they don't have to have the same process in court, but the supports underneath can all be shared. And this is what I'd alluded to earlier. This is a quotation from one of the participants about the problem when we have a never-ending rotation of people coming in and out, and why it's so important that we have a consistent and dedicated team working in these courts. I can't stress this enough, and I know as a Crown, I know in the past that there have been perspectives on, well, it's better to rotate all of our judges through because it's important for them to have the experience, or it's better if we rotate all our Crowns through. But I'm not convinced that's good for the participants, and it's not good for the experience in the court necessarily, because as I said before, the problem here is we're trying to build relationships. So when people are returning to court as they may for a check-in, for accountability, it's very important that the people in that courtroom know them as a person. They know about their lives. They know what their successes. They know what their struggles are. They know if their dog died. They know they know them. And so when they have a discussion about where they're at and what's happening, that is a meaningful discussion. And the participant, the person there, feels that these people know them and care about them and want them to succeed. I don't think you can achieve that with a constant changing face on the bench, or even with your lawyers and your team. That doesn't mean you have to have one judge and that's all they do. If you're a large jurisdiction, you can have a dedicated team, but then you need to create a database, some form, almost like a bench book, where you can record that information so that everyone knows everything. Everyone shares that information about those people and what they know. So when someone shows up in the next appearance, even if it's a different member of the team, that team member already knows what some of those discussions were and knows about that person. Funding, predictability, obviously adequate and predictable funding is critical for stability. Predictability is critical to success. We can keep yelling that message and hope that it gets heard. Stable housing, without exception, actually one exception, St. John's, Newfoundland, seem to have their housing situation in a better control for whatever reason than everyone else in Canada, who identified stable housing as the single most important factor. Because of course, if you don't have stable housing, then you don't have stability. And as the one participant said, participants are not going to succeed if we put them into the shelter system. Living in a shelter is not a recipe for success. That's an emergency. Whoops, did I go back? There we go. Intake and screening tools and care plans. And you're going to hear a lot about this in fact, I think you're going to hear about trauma-informed processes in the presentation that follows me. But the importance of intake and screening tools and support plans that are evidence-based, trauma-informed, culturally appropriate, and individualized. There's an example I put in the slide of a level of service case management inventory and approach used in Dartmouth, Nova Scotia, where they're trying to do exactly that and achieve those characteristics in their screening. Information protocols, and this is, I have to acknowledge, probably going to be very challenging. We talked about the information that you want to get access to for your measurement and evaluation. That's going to require you to have information protocols to break down the silos that exist between health and justice and other sectors, to find a way so that when you have an individual who's starting to participate in one of these courts, that you've got timely access to legal and medical information so that you can really know this person and understand as best as possible what their needs were, or at least your starting point for your ongoing assessment. Another recommendation, seek early input from complainants. It's easy to forget about someone who may have been impacted by whatever conduct has brought this person to court. It's important, even in the therapeutic court context, to think about input from the complainants. Nova Scotia has a victim's voice statement. You can find it on their online website, which seeks information from the complainant about how they've been affected by the conduct. It's obvious that this sort of information, when you think about it, it's relevant to diversion and the plan for diversion, but it also fosters a restorative approach, which I think is also an important goal. Another 10th recommendation is to improve access for Indigenous and racialized communities. This is a challenge not just in the north, but also in our large cities in the south. The Nunavut Therapeutic Justice Program was an example of culturally appropriate programming, where they have built culturally appropriate life skills into their programming, on the land activities, hunting and fishing with elders, for example. There's also, though, a report, it's referred to in our report, Racialized Populations and Mental Health Court Diversion. It was written collaboratively with a number of mental health organizations in May of 2019. And it really does a nice review of the challenges for racialized participants and their ability to access these courts. A lot of it, as you can see, is based in lack of information, lack of awareness, both about these diversion programs, but the sort of court and legal process generally. and other factors that are no surprise: poverty, migration, and the distrust and loss of hope in the justice system. These all need to be addressed to make these programs successful. And this feeds into recommendation number 11, which is this idea of an online presence about information, access to information. Quotes from our professionals working, how accessibility and awareness are hand in hand, and the big public gap in knowledge about what everyone is doing in these courts. If you do and when you look at our appendices in this report, we've included information about what online information is available in each of these jurisdictions for each of these courts. It's really interesting. It is across the board a range, everything from paper pamphlets that are available in the courthouse to a robust online website that is current and has a lot of information in it. So I think we need to be thinking about these programs just like you might think about any kind of service where you have a customer, a client, where you want to make sure that they know what is it that you do, when are you open, where are you located, what are your purposes, objectives, what are your policies, what are your best practices, what is the eligibility criteria. Have you measured and evaluated put your evaluations on the website so people can see it? Contact information, photos, pictures of what it looks like in these courtrooms. And I can only commend you, and I've put a link in the site here. Nova Scotia has YouTube videos showing you what it's like to be in these courtrooms. The Chief Justice, Pamela Williams, being interviewed and talking about what the Nova Scotia court does and how they think about it. And all of that can only increase someone's confidence and perhaps lower their levels of anxiety and apprehension about participating in something that is like a black box, right? So as soon as you can see it and you can appreciate it, I would think that you might be more open to giving it a try and might come to that experience more willing, perhaps, and open to that participation, which can only be better for success. And the last recommendation is, again, to deal with evaluation and measurement. And I know you're going to hear about that again on Wednesday in great detail, which is really great because I think this is, again, a very challenging area. A lot of us, depending on our expertise, we're lawyers or mental health or other treatment professionals, we have a lot of skill in certain areas, but conducting surveys or doing evaluations may not be one of them. And that's not surprising. You know, do we understand the difference between quantitative and qualitative assessments? And how those might be conducted. As I said earlier, identifying what is it you're measuring? What does success look like? What do you think success looks like? What is it what's your goal? What are you aiming for? Do you have the data? Do you have the information? If you don't, can you go and get it? There are assessments, as you'll see in the slide, from across Canada. I've noted BC, Saskatchewan, and Nova Scotia, among others, and those are available. You can see them and give you an idea as to how yours might look. There's also a really helpful report from the University of New Brunswick that was written in 2016, and it's about how to do an assessment. And it was written for the Canadian Council of Chief Judges, and it offers different models of assessment. And some are, the Cadillac model, which would involve hiring and retaining experts in this field. But it also contemplates other ways of doing measurement that aren't perhaps as budget unfriendly. And it could involve, as I said earlier, pairing with a university where it's an academic project, but it will also support this court process. And it's really interesting when you look at some of the reports that have been done. And they're referred to in our report. The federal government has done literature review and surveys. It was from 2015, concluding there was a continuing need for drug treatment courts. Fine. But Calgary in 2019 attempted a quantitative analysis of their drug treatment courts and reported, and this is just to give you an idea of types of measurement, a 38% reduction in relapse. 55% of the people who came through stayed sober for 6 months or longer. 87 graduates had a 76% reduction in the number of criminal convictions. Calgary reports a savings of $76 million relating to the cost of stolen goods, and $7.4 million savings from the cost of jail. Participants were also assessed, and they described their experience as life-changing. So you've got Peterborough and Durham, they've reported reduced recidivism, and the Yukon has also done an assessment and reported how their community wellness court became an important and useful additional restorative justice alternative with a profound effect on reducing the underlying issues of addictions and mental health problems. So there are lots of studies out there. You know, you can look closely at them and see if they give you some inspiration. So that's the macro view. I went through it very quickly. I know the slides will be available. I just want to thank you for giving me the chance to share this information, and I hope that you can share it with others. And about the resources in this report that I'm hoping, and we're all hoping, will help you in the work that you do so well. It's got a wealth of tools to support all of your hard work. So again, thank you.
All right. Susan, amazing presentation. Thank you. I think as you were presenting, I thought I was actually listening to a social worker, because this is the kind of discussions we have in our classrooms, right? In terms of, you know, giving the end user more control and believing that we are not the experts, that they do carry that expertise, and that we as service providers need to reach out and to tap into that expertise. So I think you made that really crystal clear, that a lot of times it's not about the techniques, it's not about the policy procedures. You know, reminds me of that saying, nothing without us, nothing about us without us. You know, kind of thing.
Well, and you know, I think we can all get bound up in thinking about what we do, and that's our focus. But we need to think about the people we're doing it for. Like, we really do need to think about, I don't know if you want to call it the end user, but you really, I mean, I think our healthcare system needs to do that.
Yes.
I think that it's true in many, many places. And we need to start thinking about that. In addition to your point and Justice Barnes' point earlier, how much we have to learn from each other. And to continue to learn from each other. And that's what this report was let's find out what everyone knows now and share it. And I hope that people will continue and be inspired to start saying, you know, we need to be talking to each other and sharing what we already know and build on that.
Yeah, amazing. I so relate to what you said, even though I have nothing to do with law, I'm social work, but amazing. I think this is where the rest of the world should be headed, or is heading, in terms of you know, not considering ourselves as total experts and kind of wearing that hat and trying to perpetuate a system that is sometimes comes across as very oppressive to the end user. And I think by the statistics you quoted, the property, the money saved, all of those things, I think is a proof that these systems do work. And I want to thank you. Thank you.
Well, that's the numbers. Some people need numbers, right? And sometimes government needs numbers, right? To justify their expenditures. So it's possible to create those numbers. But of course, numbers aren't everything. It is that qualitative experience piece that's also so important. So but you can do both. You don't have to do just one.
Amazing. I mean, thank you, Susan. Thank you.
You're most welcome.
I'm so excited about this. Thank you.
Good.
So thank you. What we'll do is let's get our next speaker. Our next speaker is Lindsay Price Jackson. Again, Lindsay is a senior program manager in training and technical assistance team at the Center for Justice and Innovation. With this team, she trains and consults with jurisdiction nationally and internationally as they implement community justice initiative. Before joining the center, Jackson conducted research consulting projects with United Nations, universities, Delta 8.7 project on human trafficking, with Arnold's Venture Pretrial Justice Initiative on prosecutorial discretion and on reform prosecution nationwide, and with Vera Institute of Justice. Jackson began her career as a public defender at the Defender Association of Philadelphia, including volunteering in the problem-solving project Dawn Court for women with criminal histories of drug and prostitution offenses. Jackson holds a law degree from the Penn State University, and a Master of Public Administration from New York University. Thank you, Lindsay. Please jump in. The floor is yours.
Oh, thank you very much. And I also would just like to introduce my colleague who's here with me, Catherine Ford. She's actually going to start us off. So Catherine, maybe you'll take a minute to share a little about yourself and get our slide deck going.
Yes, hi, and good morning, everyone. Thanks, Lindsay. I will go ahead and share screen, and then you can see a little bit more about us. Hopefully that's working.
Oh, yes.
Yes. Okay, excellent. Thank you for that kind introduction. So Lindsay and I both work at the Center for Justice Innovation. We're a large justice reform nonprofit based in New York City, although we also have operating programs in upstate New York and in New Jersey and now in Los Angeles. And we do a variety of things, including research. We have over 60 operating programs in those areas where we implement and evaluate innovative justice practices. And Lindsay and I today are primarily representing the center's technical assistance teams. So I'm a part of the Gender and Family Justice team and the Tribal Justice Exchange teams at the center, providing national training and technical assistance primarily on violence and victimization issues, including trauma-informed practices. And as well, for 9 years, I was a trauma therapist for children and teens at one of the center's small operating programs, which is called Bronx Child Trauma Support. So I'll be speaking from all of those experiences today. And I know Lindsay will be speaking from the diversity of her personal and professional experiences as well. So thank you again for having us. Just to give you a little overview of what we'll be talking about today, we only have 40 minutes and we have a lot to cover, a very, very big topic. So this will really just be kind of an introduction or maybe a review for some of you who've already had some training on trauma and trauma-informed practices. But we'll start by talking about what is trauma, what are the ways it can affect us as human beings, having those types of experiences. Then talking about why we should consider trauma in courts, particularly in treatment court settings. And then we will be providing some specific suggestions for practices that can be used in the courtroom that are trauma informed, that take into account the fact that the majority of your litigants will have had traumatic experiences that may be affecting them. And so how can we support them? How can we identify that and provide supportive resources? How can we minimize the chances that we will cause additional harm or distress for them? All right, so defining trauma, there's many different definitions available out there. The one that we use here is the one from the American Psychiatric Association, DSM, but you'll hear the word trauma being used both to describe the actual experience, which we define as an experience involving the threat of or actual serious physical injury, death, and or sexual violence. And we'll talk in a moment about some examples of potentially traumatic experiences, but trauma can also be used to describe the impacts of those experiences, the responses that we have psychologically and physiologically. And again, we'll be talking much more about what that can look like. And these are experiences that, of course, because of the threat, the serious nature of the threat, they can invoke very intense fear, a sense of helplessness, horror, loss of control, disgust even, and they often overwhelm our capacity to cope because they're really experiences that are outside the realm of usual human experience. And so we'll talk more about this, but the fact that the trauma reactions or symptoms that folks may have are actually completely normal reactions and responses to experiences that are actually abnormal. And you all have probably heard this phrase before, fight, flight, or freeze. But again, because of the threatening nature of these experiences, our brains and our bodies are wired to respond in a way that is most protective for us, that helps us to survive both physically and psychologically that experience. So that could be fighting off the threat, it could be fleeing or running away, or it could be freezing. And so a metaphor I like to give is, imagine if you were like a cave person and you came back to your cave and you saw a huge bear in your cave roaring at you. What are the different things that might happen in your body and in your brain to protect you in that moment? You might fight the bear, you might run away, or you might play dead, which is like freezing. And these are things that we are kind of evolutionarily wired to do in order to protect ourselves, to survive. But the difficulty, as we'll see, is that these responses that can be very helpful in the moment and adaptive can actually cause us a lot of pain and distress when they continue after the threat has passed. So some types of traumatic experiences, trauma, the concept of psychological trauma was first identified among military personnel. It was called shell shock at the time. And certainly that is a source of traumatic experiences for many folks. We also know that sexual violence can be tremendously traumatizing, and actually among people who've experienced rape, they have among the highest rates of PTSD as opposed to other types of traumatic experiences. But we can also be traumatized by physical violence, physical assaults, of course, the violent death of a loved one, like via homicide or suicide or an accident, serious natural disasters, serious accidents and illnesses. And I should note that we can be traumatized, of course, by these things happening directly to us, but also by witnessing these things happening to someone else, and even through hearing detailed stories about traumatic experiences happening to someone else, which could be a loved one, someone in our personal life, or it could be through our work. So vicarious trauma is another topic that we don't have much time to get to today, but we can actually be traumatized ourselves as workers by hearing about and being exposed to detailed accounts of traumatic experiences of litigants or of clients. I do want to mention as well that historical and intergenerational trauma can play a very significant role. I know you all are in Canada, and so you're probably very familiar with the history of genocide against First Nations people in Canada and Native American people in the United States. So that's an example of the ways that kind of the traumatization of both individuals and communities and peoples, the effects of that can actually be passed down throughout generations. So just some examples, some statistics related to traumatic experiences in the US. I'm guessing most of these are somewhat similar to Canada, but it really to give a sense of kind of how common these types of experiences are. And these are general population statistics. So, and you can imagine as well that it's very difficult to get accurate statistics on some of these, for example, sexual abuse, intimate partner violence, because there's many reasons why folks may not disclose or reach out to help, which we'll talk more about in a bit. And many of these things do happen behind closed doors. So the statistics are always a little difficult to come by, but these are our best estimates, which is about 1 in 3 girls and 1 in 7 boys experience sexual abuse. About 1 in 4 women experience intimate partner violence, and about 10 to 20% of children are exposed to intimate partner violence. About 17% of adult women experience sexual assault. As I mentioned, one difference for Canada. So this statistic, about 22% of teens witness a shooting. My guess is that that's much lower in Canada, which is obviously a very good thing. Because you all know that the US has a very serious gun violence problem, and that relates to this homicide statistic as well, and folks being left behind by homicides. But I think everywhere there are probably high rates of polyvictimization. And what that means is that often folks are not experiencing just one incident of trauma or one type of trauma. They may be experiencing chronic trauma over different stages of their life, and often different types of traumatic experiences. So even when I was working with children and teens, a child may be 10 years old, they may be referred for example, for having experienced sexual abuse, and then we're kind of screening and assessing for other types of traumatic experiences, and they're also exposed to intimate partner violence, and or they were also exposed to community violence. So unfortunately, it's common to have multiple traumatic experiences. And in terms of the criminal legal system, again, these statistics are from the US, but they're probably pretty similar to Canada. But we do know from a lot of research at this point that the rate of traumatic experiences and PTSD is very, very high among criminal defendants and would be especially high in treatment court settings. We'll talk in a moment about the relationship between trauma and substance use. But we estimate that it's about twice as common in terms of traumatic experience among defendants, including among youth, very, very high rates of traumatic experiences and extremely high for women, to the point where I would recommend for all female defendants, essentially assuming that they've experienced violence or victimization, especially sexual abuse. There's a phenomenon called the sexual abuse to prison pipeline, even for women. So extremely common. And then in the treatment court setting, we had a little difficulty finding statistics specific to treatment court, but Lindsay did find one study from one drug court that found that 94% of treatment court litigants had reported at least one traumatic experience. So again, extremely common among the folks that you're working with. And so why consider trauma? Why are we even having this conversation today? There are clearly very significant effects on folks' mental health as well as their physical health. It does contribute to and can comprise a dynamic in someone's substance use. It can play a role in the current violence and abuse that someone may be causing harm to others through violence or abuse, and their own traumatic experiences may play a role in that. Or they may be experiencing violence or abuse currently. And also trauma really influences how folks interact with us, how they interact with us individually as practitioners, with the services that we're providing, with the legal system generally. And as I alluded to a moment ago, trauma also impacts how we respond to them. So some folks who are very traumatized may have very challenging behaviors, right? And they may trigger strong responses in us. But as I mentioned a moment ago, we can also be traumatized by being exposed to their trauma. So there's a lot of kind of interactions and variables that are at play that are trauma related in terms of kind of our work with folks. So I'm going to turn it over to Lindsay now.
Thanks, Catherine. Thanks so much. So as Catherine has really been discussing, trauma, of course, has effects on the mind and one's mental health, but it can also have lingering effects on one's physical health and overall well-being. One way that both the brain and body can be involved is demonstrated by PTSD, especially well. So we'll go to the next slide, Catherine. So PTSD is a mental health diagnosis with several criteria, per the DSM, which is that after either directly or indirectly experiencing a traumatic event that a person, one, has intrusive thoughts or memories, including thoughts of violence, perhaps, that seem to just pop out of nowhere. Number two, actively avoiding people or places or even just conversations, right, related to the traumatic event. Number three, changes in thoughts or mood. Examples of this can be disinterest in significant activities, feeling detached from others, persistent fear or anger. And then the last criteria is that someone may experience or does experience changes in their reactions, even things like automatic reactions, right? So think concentration or sleep issues, hypervigilance, think like just not being able to relax, right? You're always alert in a very extreme kind of way. So note how these are intense emotional symptoms, but with a lot of physical manifestations. So go to the next slide. Here are some examples of how PTSD symptoms may manifest in daily life. One consistent theme you'll note among court participants that we may see is our generally punitive criminal court system, right? Settings tend to lend themselves towards power struggles. So if you as a court practitioner are feeling like a conflict power struggle with a participant, the first thought should be, this is a trauma manifestation, not this is an annoying, difficult person who just doesn't want to listen. Next slide. So here's where I really want to share some firsthand experiences. It's one thing and a really good thing to talk about trauma and PTSD in terms of definitions and generalities as we've been doing, but I'm going to share what it's looked like for me as a person living with PTSD and also what I saw in court as a practitioner. recognizing others struggling with trauma and PTSD symptoms in court. I'm a lawyer, I'm a parent, right? I'm a technical assistance provider, but like so many people, including I'm sure many people on this call, I've also experienced trauma, and that trauma ultimately for me culminated in a diagnosis of PTSD. So I'll just share a little bit about that. My first symptoms were very physical, right? I grew up in Anaheim, California. That's where Disneyland is, right? If you've never been to Disneyland, they do fireworks all the time, every night. They're great. They're fabulous. I love fireworks, and every fireworks show I see anywhere else, I'm always like ranking it compared to Disneyland fireworks, right? But one, 4th of July, that's the US Independence Day. We love shooting off fireworks in the US. I was an adult, and although I wasn't feeling any fear watching fireworks, which I totally love, I physically could not keep my eyes open during the fireworks show. And when each like blast went off, my eyes would just pinch shut, my body would shudder. I physically could feel myself closing in, even though I'm like, I love fireworks. What is this about, right? At the time, I really had no idea what was going on. Now I know this as what's called an exaggerated startle response, that things just elicit a huge like almost cartoon reaction to seemingly normal day experiences. So go to the next slide, Catherine. Well, before we do that, actually go back. So I'm one, I'll just share a little bit more. I'm one for whom sudden noises, think fireworks, right? Can be a trigger to my trauma responses. And I remember once sitting of all places in church, right? Hearing a baby in several rows, not right by me, several rows behind me, crying. And my initial thoughts were of violence. And I'm a pacifist. So it's really shocking, thoughts out of your character, that's not you, that's intruding into your thoughts, right? So over time, while I was most symptomatic, I could feel myself kind of changing from extrovert to introvert, right? As far as personality change. And when any little surprise or change in schedule would happen, I overwhelmingly just felt angry, even if it was no big deal, right? So if someone like me, when I was at my most symptomatic, was sitting in court, and the court crier, without warning, suddenly shouts, "All rise," very loud right in my ear. I would have been stressed and even angry at that person, right? And if I didn't understand things in the court proceedings, and things weren't going the way I had imagined, any little change, even if it's an okay change, I would have been stressed and probably angry, right? And I would not be inclined to ask for help in those situations, but I would be inclined to really close in on myself and potentially seek comfort from negative sources, right? So the importance of being aware and empathetic of this in your practice really, to me, cannot be overstated. As a defense attorney in criminal court, drug court, human trafficking court, and so forth, I saw people tense up and react in seemingly, inappropriate ways, non-normal, right? As their trauma responses really bubbled up in those stressful situations, taking forms of anger, appearing overly demanding, right? Or being very impatient. But really, these were very real self-defense mechanisms that I was witnessing, and that we, I'm sure, all witness more regularly than we think. And these responses are kicking in because a person truly is losing control, right? Losing control of their situation, or maybe even their physical bodies and their liberties, which frankly is like a worse nightmare scenario for people who have PTSD. All right, now let's go to the next slide. So I want to think through sort of a concrete, made up, but concrete example. Let's say we have a case participant. You can see on the slide who's an African-American male. He's pretty young, 30 years old. He did experience sexual abuse as a child, and he does have substance use disorder since he was a teen, since he was young, that he's never told his probation officer about or his case manager about. He was recently arrested on some low-level charge, perhaps related to, the substance use disorder. Probation sees him as uncooperative, keeps using drugs, won't listen, got another charge, no good, right? And so, of course, he's in court for a technical violation on that because probation's insisting that this is just a bad apple who won't listen. So with the relational aspect of trauma and PTSD, it can be really hard to trust someone, especially someone like a probation officer in that authority figure related to the court, right? And to trust someone enough to disclose something like your history of sex abuse and your substance use. And perhaps let's think about how substance use may be a coping mechanism, right, for this person, or may have started as a young person as self-medicating, or started because they were not being, they were perhaps being neglected, not watched too closely at home. With all the potential courtroom triggers that I've just discussed, how can you imagine court feels for this person? Right. And most importantly, how can you help? What policies can you implement to alleviate or remove trauma triggers from your court? Think about this as an individual and as a team, and we'll have some suggestions at the end of the presentation. So go ahead to the next slide. I'll be quick. Here are a few more ways that trauma can show up in the lives of the people we serve. All right, next slide. Sorry, we have to be fast. As in our case study, let's be explicit about connecting the dots, right, between trauma and substance use, which can go together and unfortunately exacerbate one another, as outlined in these points here on this slide. Note that particularly among women, as Catherine was talking about, the overwhelming majority of females with addiction have experienced trauma in their lives. All right, we'll go to the next slide. Okay, and the last thing I'll say before turning it back to my colleague, I think it's the one before, Catherine, is that trauma also has the unfortunate effect of creating barriers to getting help. People feel stigmatized or ashamed. They avoid talking about the issue. They distrust providers, like we said, and because they're often labeled as difficult, professionals may not bother to take the time to ask them if they need help. So I'll turn it to you, Catherine.
Thanks, Lindsay. That's a great segue into our next portion, where I'm just going to talk a little bit more about some of the potential relationships between trauma and criminality, and I'm putting that in quotes, right, in terms of someone being kind of involved with the criminal legal system. So Lindsay already mentioned that, of course, like there may be substance use related crimes for which someone is arrested that relate to their substance use disorder, which may be related to underlying trauma, right? It may be self-medication. It may be a very entrenched kind of coping mechanism in terms of numbing and trauma avoidance that really helps someone to feel better in the moment, but of course can cause more long-term harms. We also know that folks who have substance use disorders may be involved with prostitution. They may be sexually exploited or trafficked. Again, there's a very strong relationship between childhood sexual abuse and prostitution and sex trafficking, and of course, relationships between those and substance use disorders. As Lindsay was talking about, someone who has PTSD may experience a lot of emotional dysregulation. They may experience angry outbursts. They may be very hypervigilant to threat. And basically what hypervigilance is that feeling that you can never relax. You're always looking over your shoulder. You're always thinking like, this person could be dangerous. This situation could be dangerous. This place could be dangerous, right? So you can never it's very difficult to just trust somebody and relax. But the difficulty there is that your brain is kind of wired to see threat everywhere. So even things that aren't actually threatening may be misperceived as threatening. So even like walking down the hallway and someone accidentally bumps your shoulder and then you punch them in the face because your brain is perceiving that as threatening. So that's something that we see sometimes as well. People who are traumatized will say, oh, somebody touched me and then I just like blacked out. And then there can be coerced or forced criminal activity, which can be present, of course, in trafficking, also in intimate partner violence. There can be an overreaction to perceived threats related to the hypervigilance, but also because of being triggered by kind of a loss of control, even like being told what to do, having to follow a lot of rules. And you know that in court, there's a lot of rules. So even that kind of loss of control or being told what to do can be a trauma reminder for someone who has experienced abuse. Folks may reenact the trauma. Lindsay mentioned kind of getting into power struggles, identifying with the aggressor, because the aggressor in a situation is the one that was more powerful and that was safer, right? So maybe I'm like kind of mimicking some of those behaviors that I have learned from being exposed to abuse. And then the response to the system and us, how does trauma play a role in that? We've alluded to some of these things, but Lindsay talked about trauma avoidance. And because the trauma symptoms are so painful and overwhelming and upsetting, people do everything that they can to not think about it, to not be reminded of it. And that includes refusing to talk about certain topics, denying or minimizing the trauma because it's just too difficult or scary or upsetting to think about it, or they just don't trust us, and often for good reason. If you've been hurt by human beings, it's going to be really hard to trust human beings. They may be triggered or upset or reminded of the traumatic experience by certain reminders in the environment, in the court environment, some of which we can predict, right? Like Lindsay talked about sudden loud noises or movements or being touched. But sometimes there's trauma reminders that we don't know about, that we can't know about. It could be like the color of shirt that you're wearing reminds you of something, or the sound of your voice, or a particular word that you use. It could really be anything that reminds the person of the traumatic experience. Folks may be non-compliant, again in quotes, with treatment. They may relapse a lot. They may stop using and then go back to using, especially if their treatment provider is not screening for addressing underlying trauma. It can be completely terrifying actually to go to treatment and to stop using when you have PTSD, because then it can feel like there's no way to numb yourself from the trauma memories, from the trauma symptoms. And we talked about the power struggles already. So really the key question for trauma survivors, this may be a question they're aware of or a question that they are unaware of, but is really, again, about a survival instinct, is what can I do to survive, physically survive and psychologically survive, and have some sense of control, again, when control has been completely taken from me during the traumatic experience, in this world that I'm perceiving as terrifying, violent, and unpredictable. So again, when we're thinking about kind of the symptoms and the behaviors in that way, it actually makes sense. So these trauma symptoms are, again, they're attempts to survive physically and psychologically, to protect ourselves from ongoing harm. They're adaptations. Again, they work. That's why they become very entrenched. Some of these symptoms and behaviors, someone may have had them for 30 years, 40 years, right? Because at the time, they help them survive. They help them feel better. So they can become very entrenched. And again, the symptoms appear logical. They make sense once we know the trauma history that the person has experienced, right? Sometimes we as providers can have an aha moment, like, that's why you do all those things that drive me crazy, right? It's not the person actually, being difficult. Lindsay mentioned that sometimes these folks who are very traumatized, they kind of get a bad rap because they can be very challenging for us to work with. But again, once we learn about the trauma history, it actually makes sense. So what happens if let me just make sure this is me, I think it is. What happens if we miss trauma? We really miss the boat, because often it's trauma that's driving someone's substance use disorder, that may be underlying their mental health issues, that may be really underlying their criminal legal system involvement. And so if we're not addressing the trauma, folks can just keep cycling in and out of the system. And these are the folks that we see who have 40 arrests, right? And nothing seems to work or stick or take. We can also inadvertently trigger folks and even re-victimize them through our legal system processes. We misdiagnose folks, we mistreat them. So we're giving them diagnoses that are actually not accurate. We may be giving them treatments that are not only ineffective, but that can actually be harmful to them, which is a big issue, that some folks who are very traumatized may be diagnosed with other things, oppositional defiant disorder, bipolar disorder, ADHD, et cetera, and not with PTSD. And again, we're missing an opportunity to get folks the help they need and to prevent additional violence, to interrupt that cycle of violence and to stop the revolving doors of the system. So what are some of the trauma-informed responses that we want to recommend? So these are kind of general principles, I'd say. We could talk about each of these much more. But a really, really important first one is just thinking about training for staff, really everyone that interacts with litigants. So not just judges, not just attorneys, but everybody, including court security, including like a front desk person, right? Because all of these folks play a role in how the person is experiencing and interacting with the criminal legal system. And any of them could be inadvertently triggering and or could be supportive, right? Could help somebody feel a little bit safer, a little more in control. So really training and kind of being able to view folks who are traumatized and their behaviors from a different lens with a different kind of philosophy or approach is really, really critical to all of this. Screening and assessment, and this looks differently depending on your role and your setting, but there's two types of screening and assessment really. So one is screening for potentially traumatic experiences, and there are tools for that. Like there's one called the Trauma History Questionnaire, but then also screening and assessment for PTSD. So there's other tools for that purpose, such as the PTSD checklist, the PCL. And depending on your setting, again, and your role, some of these different tools may be appropriate. There's also very brief screening tools available online. At the U.S. Veterans Affairs Administration, they have a really brief screener. It's literally like 3 questions, which can be a really good starting point. And then we really want to focus on creating a comfortable and empowering environment and relationships with folks to the extent possible, again, within our role. But it's really important for folks to feel as physically and psychologically safe as possible. That requires kind of partnering with folks kind of as a team, offering opportunities for choice and decision-making, helping folks understand what's happening in the criminal legal system. Lindsay mentioned that kind of the more that we're overwhelmed and confused about what's happening, the more stressful and potentially triggering it's going to be, again, from that kind of that sense of loss of control. Connecting people with victim services and other trauma care, including trauma-informed, trauma-specific mental health and substance use treatment is very, very, very important. And I think something that treatment courts can really make a lot of difference around in terms of actually assessing the degree to which the treatment providers that you're referring to are trauma-informed and are addressing trauma, because again, if trauma is not addressed, the treatment's unlikely to be successful. And so speaking of incorporating trauma issues into treatment, there's a lot of different ways to do that, which we don't have time to cover today. But again, these are really important questions to ask as a treatment court team of your treatment providers. And really, the last thing I'll say is I just really appreciate this quote. This was from a woman, Tanya Kane, who really, her life experience was reflective of a lot of these dynamics. She had been sexually abused as a child, and she had like 30 arrests for low-level stuff, you know, violations and misdemeanors, prostitution-related offenses, you know, drug possession, et cetera, really cycling in and out of the system. And it wasn't until a substance use treatment provider actually asked about trauma and addressed her trauma that she was able to get effective treatment for her substance use disorder. And now she actually is a speaker for the National Center for Trauma-Informed Care. And she really talks about how the goal of trauma-informed practice is to really move our systems and our responses from this kind of reflexive, what's wrong with you? Like, what's up? You know, again, labeling folks as like, oh, they're so difficult, they're a bad egg, right? They're so challenging, you know, so moving from that, and the system again is set up to be punitive in nature, shifting the system from that kind of reflexive response to a response of what happened to you, right? Thinking about what is, you know, what are the potentially traumatic experiences that are leading to your involvement with the criminal legal system, and that really help us to kind of empathically connect with you and understand what's going on and what's underlying your behaviors and how we can best support you and help you heal. So turning it back over to Lindsay, take us home.
Sure. Yeah, I'll finish this out with a few more strategies for practitioners. So look at these here on the screen. When someone is experiencing distress, how can we help them? Grounding, right? We can help bring their focus back to the moment, back to the present, rather than what crazy, scary thing might maybe happen down the line. We can take them aside and offer to do, even though you might feel weird doing it, 3 deep belly breaths with them together. I use this on my toddler, so multiple applications. Okay. We can guide them to push negative thoughts away, right? In meditation, if you're familiar, people are sometimes encouraged to think of unwanted thoughts like leaves gently blowing away. You can kind of use that visual with folks, if it makes sense. And we can encourage people to give themselves a positive pep talk. You know, most of us do this all the time. All right, you can do it. You can do it. I always talk to myself the way that my 7th grade coach said, okay, Price, you could do this. You know? So how can you offer choice, right? Because control is a major issue. How can you offer choice and impart a sense of control to case participants? That's something we'd love you to think about. How can you communicate a spirit of partnership? And how might you maximize predictability for participants? All right, next slide. Just a few more on the screen for you to look at. Has your court applied any of the following practices? Think through that and check all that apply, you know, kind of in your mind, and write down the ones perhaps that you might want to work on or bring to your next team meeting. Next slide. Here's the list continued. I'll let you read through them.
And I'll just say that you'll see that these practices really reflect a lot of what we've been talking about, right? In terms of empowerment, offering opportunities for choice, thinking about the sensory experience of trauma, like minimizing distressing sensory experiences, minimizing physical contact or touch, providing a safe, you know, a calming space in the courthouse, incorporating mental health support on site. All of these kind of things can be very helpful.
Thanks, Catherine. And then I'll just show a few additional resources. These are 3 organizations you might want to look towards if you want to learn more online.
Yeah, and I'll just say that the second one, although it says domestic violence, is actually general to trauma-informed practice, and they have some really, really wonderful resources online, even just like fact sheets, like 1 or 2 page tools for like how to create like a trauma-informed space, a trauma-informed environment, how to like create a sense of emotional and psychological safety in your work. So that I really recommend their website because they have a lot of very, very useful and practical tools for practitioners.
Perfect. And we really appreciate having the chance to speak with you today. Thank you.
Yeah, thanks everyone. I think we have 3 minutes for any questions. But I do want to encourage everyone as well. You'll see our email addresses on the slide, and we'd be happy to hear from you anytime. We're happy to provide more resources by email or talk through some of the issues that you're working through related to trauma-informed practice in your treatment court. So please don't hesitate to use us as a resource as well. Are there any questions?
I don't see any in the question here. I don't see any hands raised. But before we end, Catherine, I owe you a big apology. I did see your description, but much later after I read. So just quickly wanted to kind of talk a little bit about Catherine. Catherine is a licensed social worker, provides training, technical assistance to the state tribal justice system, practitioners nationally through both the Tribal Justice Exchange and the Gender and Family Justice team. In addition, as the center's director of the clinical supervision, Catherine coordinates agency-wide clinical practice initiative, and the center's direct practice staff have access to the clinical supervision and training. By the way, Catherine holds 2 masters, one in, of course, social work from Columbia University, and the other one is public health at Johns Hopkins University. My apologies to you, Catherine, but Lindsay, Catherine, amazing presentation. I think while you were doing the presentation, it reminded me of trauma. Trauma has become such a huge, big concept that I think connects the micro with the macro and micro. It connects our structures, right? We talk about historical trauma, the trauma of indigenous. We talk about the trauma, of incidents. We talk about the adverse childhood experiences. I think a lot of times, some of the stuff that I know about trauma is that trauma is almost like a chameleon. It can appear like depression. It can appear like ADHD. It can appear like psychosis. It has so many different shapes and forms that trauma can take. And I think part of our challenge as practitioner is what's happening, as I think Lindsay and Catherine very clearly stated, what's happening with this person, I have no idea, right? Unless you know what the trauma is, unless you ask the right question, as I think very eloquently stated, what's not what's wrong with you, but rather than what happened to you. I think amazing. Thank you for this presentation. I'm having a great time. I don't know about you guys, but thank you. So our next speaker, wow, I'm so impressed. I don't know. I just like, wow. Our next speaker today is Richard Sharp, and a little bit of about Richard Sharp before we get into the present. So Richard, again, has been a human rights advocate for 30 years. 30 years, both at community and institutional level. Until recently, he has worked with the Canadian Federal Public Services, where he held several national positions representing employees as both union rep as well as a leader in the employee-led organization. He is currently the director of the Black Equity Branch Treasury Secretariat at the Ontario Public Service. His work regionally and nationally is intended to improve the conditions of Black and African diaspora in the communities in Canada. So yeah, Richard, thank you. Take over. I think you might be on mute, Richard. Yeah, I don't see the microphone. I don't think your microphone might be connected, or the headset might not be connected, because I don't see a microphone here at my end. So I see one hand up. Darlene, maybe we'll come back to you after Richard's presentation. Sorry about that. I missed that, Darlene. So yeah, Richard, maybe if you want to even log off, come back in and see if that will work. So Richard, I think, is logged off. Hopefully when he comes back, his microphone should work. Darlene, if you have a quick question, you want to quickly jump in until the time Richard joins us. If you want to unmute yourself and. You there, Darlene? I'm not sure, Darlene, if you are speaking, and maybe you are on mute. Okay, let's try that. Darlene, are you there? Let me see if I can unmute. Yeah, so Darlene, go ahead, unmute yourself.
Hi, yeah, you have to excuse me. I have a bad chest cold thing here going on, but yeah, I just had more questions about the second last slide from the previous speaker.
Okay.
And just more, what's the word I'm looking for? Strategies for PTSD. Okay. They had put some on there, like creating a quiet space, providing choices to clients, or self. And yeah, I don't have that screen in front of me.
Yeah. All right, so let's do this, Darlene. Let Richard complete his slide, and maybe during the break, if Lindsay and Catherine can quickly kind of answer your question or maybe put some link in the chat for you. Would that be okay, Darlene?
Yeah, that would be good. I thought you were asking pertaining to the previous speakers.
Yeah.
Okay.
Same here. I did, but Richard is here, and let's hear Richard, and then maybe during the break we'll get some time to catch up in terms of our question, if you're okay with that.
Yes, thank you.
All right, thank you, Darlene. All right, Richard, can you say something? Let's just see if it's working.
Testing 1, 2, 3.
Oh,
testing.
yes, you are in business. Please, Richard, thank you.
Okay, thank you very much for the introduction. I was saying when you couldn't hear me that your introduction about me being around for doing this work for 30 years makes me feel really old. But I have to say that I'm still having a really good time. This is important work, and I'm happy to be here today. I did want to talk a little bit, and I don't have slides today because I'm hoping that it will be a bit more of a conversation and a back and forth, which tend to be a bit more engaging for me, at least, around anti-Black racism in the justice system and its impacts on the people who are part of the justice system, or I will say the legal system, because I don't see that there's, even though I've been working at the Department of Justice for a couple of years as an executive pushing this work, I see a distinction between justice systems and legal systems. Because justice systems means you have redress and that people come out of the other end whole and with issues addressed, and they have their humanity. And legal systems oftentimes do a whole bunch of different things, but don't always uphold the human rights or equity of individuals. So I did want to talk a little bit about the difference between the two, or just talk about, what justice is supposed to do, or justice systems are supposed to do. I think that most people believe that justice systems are in place to keep people safe, to keep us safe from the bad guys. So police go out there and they round up the bad guys, and we can walk the streets without worrying about getting mugged or things taken away from us or being harmed. But is this actually the function of, say, policing and the justice system? Do we actually keep everybody safe, or do we keep some people safe and do harm to others? And I think that is what precedes a lot of the conversations that I've been having within the systems of the federal government and now the provincial government, where I'm the director of the Black Equity Branch, a remarkable and historic creation of an institutional office and body to address longstanding issues of anti-Black racism within the Ontario Public Service, work that I had hoped to do and was trying to work with federal officials to have put in place in the federal public service before I left, but that's yet another story. So certainly from my perspective and my years of doing this work, I see that justice doesn't actually necessarily keep people safe, but it has a different function. And that function is oftentimes to maintain control and to maintain a level of status quo in terms of power within a society. So, and who are the people who are the most impacted by power and the status quo? Oftentimes, and we see this through a number of statistical data analysis from Stats Canada to research and other findings, that people of African descent, Indigenous people in this country, are the most negatively impacted by the justice system. And this starts from, they say cradle to grave. The school to prison pipeline, as they call it, for Black folk in particular, where people are identified within the systems of education, systems of policing, the carceral system, policings of taxing and all that sort of thing, gears particular groups in our society to be less well off and actually to feel, I think, oftentimes marginalized and targeted by these systems. I'm going to give you a little mini history lesson because I don't want to bore people with some of this stuff. But when we talk about, for example, the origins of policing, the origins of policing in Canada, and this is, and I would say, pre 1834 which was the emancipation of enslavement of African peoples in the Commonwealth countries, Canada had a police force that was here to help maintain and support the colonialism of this land, the RCMP and the organization that preceded the Ontario Provincial Police, in particular in what was called Upper Canada, were charged with making sure that enslaved Africans were not straying too far away from their owners, and that they carried their identity papers so that people could identify where they belonged. So that practice of identity papers and became modern day carding. And so even though it's a human rights violation and it's been expressed as a human rights violation by dozens of people, it's still really hard to undo, because this is the raison d'etre. This is why our policing was put in place. And so if you're founded to do one thing, it is difficult to modernize and have it change without changing its purpose, without changing its foundational purpose. So there are folks that would like us to, continue with the good old days, but that hasn't worked for a large and growing number of our members of our society, who are the fastest growing populations in Canada right now are Black and Indigenous communities. So Canada is going to be a very different place in 30 years. There's going to be a lot more people running around doing this work. I hopefully will be well retired by then and sitting on a beach somewhere, while my children and my grandchildren, I hope, are not still doing this work. But I'm not holding my hopes up just yet. I would also want to talk about the justice system. So what we call the justice system, the foundations of the justice system, the Department of Justice Canada, was founded over 189, maybe 190 years ago as the first federal department. And it's pretty much its first order of business was to legalize the colonization of this country, and to put in laws and regulations to keep certain people out, and to justify enslavement and later on segregation, similar to what we had in Jim Crow US, within the Canadian population, that we normalize this, we bake this into our laws. So in order to do that, there's needed to be systems of education and indoctrination supported by the church at the time to help to justify marginalizing and keeping sort of Black and Indigenous people down. So this has had an impact, because this is our founding fathers, if you want to call them, the European colonizers, the settlers of this place. The first prime minister said, we have to make sure that Canada is white and keeping Asians and other people out. This foundation became what we have now today. The leftovers of that, the vestiges of that, is what we have to deal with today. So what we're seeing in terms of communications, what we're seeing in almost every facet of our lives, is an undertone of anti-Blackness that impacts on the policy and the program development and implementation within all sectors of our lives. The United Nations came to Canada in 2015 and 2016 to do, the Human Rights Council, to do some work on assessing the state of people of African descent in this country. And they were opened up, the doors opened up. Well, we have multiculturalism and we have employment equity, we have human rights legislation, things are good, Black people are happy. But what the UN found in this investigation, in this study, and these conversations, was that anti-Black racism is so embedded in the fabric of Canada that it is normalized. It is normal for 20% of Black boys not to graduate from high school. It is normal to have 3 times the overrepresentation of Black people in the in the carceral system. It is normal for people to perceive that Black people are criminals and rapists and doing all kinds of other criminal activity. And that is baked into the thinking of the people who run these policies and programs and so on. So if we have these things that have been taught to us quietly, informally, and politely since we were small, to when we become adults and we're working in these institutions, it is obvious as to why we're seeing such high rates of, and we're seeing it now as numbers grow within our workplaces of complaints of discrimination, of workplace discrimination, of harassment, and illness. And I appreciated the comments of the previous presenters who were talking about trauma, the vestiges of this, the impacts of living in a society. And I was born in Canada, so I know, I could tell you stories from my childhood up until today. The impacts of this on people is deep-seated trauma. And I would say generational trauma, because we pass this trauma down to our children and our grandchildren who continue to face exactly the same things. That trauma can be debilitating. It creates all forms of dysfunction, dysfunctional behavior, as was discussed in the previous presentation, illness, and other forms of harm. So, and in fact, one of the sort of remarkable things, and people, because I end up dealing with so much of this harm, I think I'm hardwired not to be impacted as much by it. But the cycles of violence and the cycles of hurt and pain transcend, like I said, generations. So my father, who was a university-educated, master's-educated teacher from Oxford University in England, when he came here, couldn't find a job for like 25 years. That impacted us economically. It impacted my mom, who had to become the breadwinner without a high school education. It impacted the 6 of us children in terms of our socioeconomic status. It impacted our ability to go to school. It impacted our ability to go to university. It impacted our ability to get work. It took me much longer as a Black man to get work in this society because of the injustices that were sort of baked into it. So because I look at the source of problems, and I could talk all day about the symptoms and the impacts of it, but I like to talk about solutions. And talking about solutions for me means to embrace others within this work. After the murder of George Floyd, and where we saw in that 8 minutes and 46 seconds, the extinguishing of Black life under the knee of a white supremacist agent of the state in the US, we all realize that this is what happens to us as Black people, not just when we encounter policing, but in all of these other institutions that we face in one way, shape, or another. So we do so, some of us try to do it with grace, and some of us can't, right? And so the ones that can't oftentimes are the ones that get ensnared within our justice systems. And so it's with that understanding that these are systems that can harm. These are systems that have continually harmed, and that many people don't see it. It requires work at a really deep-seated level. It requires work, like I said, with co-conspirators, not just allies, to reset things, if not reimagine what policing looks like, what justice systems look like. I spent a lot of time over the last couple of years supporting something called the UN International Decade for People of African Descent. I don't know if anybody on this call has heard of the UN Decade. It started in 2015 and goes to 2024. So next year is the end of the decade. This is similar to the International Decade for Indigenous peoples that preceded it. It's been pretty quiet in Canada, as much as many of us have been pushing for it, but pushing for it to instill some of the pillars of the decade, which spoke to recognition, justice, and development. I stayed in government just so that I could work on this file, or try to push this file with senior levels of government, because I understood that if we can make some changes at an institutional level, the lives of people who look like me would be better. Wasn't entirely successful. I think that there's a need for an extension of another 10 years, the decade. But what I will say is that one of the and what relates back to this conference, one of the big pieces of the initiatives that we were pushing forward, myself and other community folks and folks in government, is a Black Canadian justice strategy, or so a Black Canadian justice strategy that's hinged on the fact and the knowledge and the data that Black people are not being served by justice system at multiple levels. We saw recently that even at the Human Rights Commission, has been harming Black employees, or has found to be harming Black employees. And so all the things that we were saying for the last 20 years about the Human Rights Commission not serving our communities, and now the chickens have come home to roost, and now we're seeing that this is the case. And if one of the most prestigious institutions in this country that speaks to human rights has failed us, then what do you think about all the other institutions in this country that are sort of linking up to the Human Rights Commission? So a justice strategy is critically important. And why I raise this is that, in my estimation, that this work has stalled in a way that we've lost sight of what actually needs to be done in terms of the outcomes that we're looking for. In my past life, I was a manager of performance measurement for one of the largest departments in federal public services and procurement Canada. And I know full well that if you measure and you set outcomes that are ambitious, and that you set a number of metrics behind it, that you will work towards achieving the results of the initiative or of the change, right? So for me, and I think for countless others, Black activists, policy analysts, and even people who are not part of the Black community, what we were hoping for was that the justice strategy itself could serve as a means of relooking at how justice is meted out within this country, at least at the federal level, and impact the provinces as well, because the provinces and the feds have a symbiotic relationship as it pertains to how justice, the discipline of justice is meted out to, for, and against people. But a systemic approach that speaks to things like, looking at the history, as the previous speakers were stating, like, look at the history of trauma on folks who are still struggling with trauma. This is history of over-policing, the history of enslavement, the history of slave catching, the over-proliferation of negative stereotypes within our society about Black people, how that impacts on jurors, on judges, and all of the justice of the peace, and all of these people that impact on the lives of our people, that we need to look at something similar to a GLADU recommendations to support Indigenous people and always have an Indigenous lens, that our justice system needs to have a Black lens that takes into consideration all of those things that I have stated, so that at the end of the day, what we come out is actually exercises and actually restorative justice, a reparatory justice, when it comes to the treatment of Black people who, as I keep saying, have been ensnared in the system since they were small. Just a couple of stories before I shut down my talk, because I could talk all day about this kind of stuff, is that I have 3 children that I love dearly. I think, in fact, it's absolutely true. I came out of retirement to come back into this work because my son was experiencing challenges in school. And at one point in 2017, he was suspended for challenging a teacher for a principal for racially profiling him. It actually made the news. And there's a Toronto Star article about Mandela and his travails and actually success, because he overcame some of those challenges. But part of those conversations around my children is that we knew that our children would be targeted from the time that they set foot into a school. And it was exactly right. At grade 2, he was targeted. He was too athletic. He was too talkative. He all asked too many questions. They found that he was not cooperative. He always wanted to play outside with the ball. And so that became a problem. So much so that we ended up deciding to take him out of school because we found that wasn't a safe place for him, and we homeschooled him for 5 years. Asked him what he wanted to do with his life. He said he wanted to be a professional soccer player at 7 years old. And we said, well, get yourself an education, we'll see what happens. Long story short for him is that he's now playing semi-professional soccer in Toronto as we speak, having gone through the university system and now taking his chances in that space. But many of his peers are in prison. Many of his peers are unwell. Many of his peers that he went to school with have not succeeded in their lives, partly because of how they were also treated in those systems. So I say that because of how deeply this runs. When we're talking about justice, reparatory justice, and systems, that we're not just talking, and when we're talking about a justice strategy, we're not just talking about the justice system itself, but we're also needing to talk about all of those things that feed into the justice system: education, child welfare, the healthcare system, policing, of course, right? All of these things kind of line things up when these things, housing, when these things are not working for us. And I know because of my dad's situation, we grew up in poverty, and I was this close to becoming a criminal mastermind, trying to take over the world, that which probably would have gotten me either killed or in prison. But all that to say is that all of these things make up a just society. And if we actually believe in this concept of a just society, then we actually have to do the work. And I think oftentimes we don't. We leave it to other people who are mandarins of justice, mandarins of this or that, to come up with these ideas and policy recommendations and programs for us without actually being part of that work and asking the right questions. Is this data informed? Are we including the people who are the most impacted by these policies and programs? And what are the outcomes that we want to achieve from these initiatives? Will they bear fruit in de-escalating the amount of crime that we see? Will they bear fruit in terms of not over-policing or over-targeting or over-ensnaring Black and Indigenous people into our justice systems? In many ways, it's interesting to me that now that I'm doing work on the international stage, I went to the UN Geneva in December to support the first permanent forum for people of African descent. I was asked to attend by a couple of UN fellows and continue to do work in this space. It's interesting to me that how much Canada's treatment of Black people is known across the diaspora in other member states. So this is an issue for Canada, not just domestically in terms of our souls as people who live here, but it also will impact us in terms of our desire to engage with those member state countries and countries on the continent, that new frontier of opportunity, wealth, in terms of resources, both human and mineral and so on, that we need to think about how we treat our people here who are the direct descendants. We're considered the sixth region from the continent, those who are from the diaspora. So I think it's really important and incumbent on us to get this stuff right, not just for sort of the economic reasons and the political reasons, but also for to ensure that we as a society can maintain our collective humanity. And that's a difficult and long conversation to have, because I think many of us know that what I'm talking about is true, and that it seems very difficult and overwhelming to address, but in actuality, it's a one step at a time thing, and it requires us to sort of recognize and face the reality that we live in a society that practices anti-Black racism through its justice system. So I'll end there. Again, I'm happy to be part of a conversation, answering the questions that I can. I kind of skirted over stuff. I wasn't giving people numbers and that kind of stuff because that really bores people. But I'm really interested to hear what people have to think on some of the things that I said, and hoping that this conversation goes beyond just a talk and translates into folks willing to work with, I would say, like minds, to address some of these challenges that we have within our systems for the betterment of our societies. So thank you for the opportunity.
Yeah, Richard, thank you. I'm seeing something in the chat. There are some questions. All right, so whoever wants to ask questions, please raise your hand. In the sense, raise your hand. Under the reaction, there is a function there, raise hand. If you can click that and ask questions or put something in the chat. And there is one question here. It says, Richard, I love that you call it out. You call it the legal system and not the justice system. I do as well. So this is just a comment there for you, Richard. And then I'm needing to know if if you, what happens is by default, everyone is muted. But if you have a question, please use that raise hand feature, and I'll unmute you. Please feel free to ask questions. Until the time there are some hands up. For me, Richard, the way I kind of looked at when I heard you, it reminded me, a friend of mine was complaining, about the police brutality. And he said, "What's wrong with these police?" And my response to him was, "There's nothing wrong with the police. I think the system is working as designed." I think a lot of people kind of look at these different, the Children's Aid Society you talk about the police, you talk about even the whole criminal justice system. A lot of times people seems to think that these are just a few bad apples. My take, I totally agree with you. I think the system itself is rotten. There's nothing wrong with the system. I think, as you said, right, if you look historically, the whole carding system, right, it was designed basically to control and contain, right, both indigenous and Black communities. So it's the same system that's being passed on to us. So we should not be surprised that it's, anyway, those are some thoughts that came to my mind. I don't know, Richard, if you want to kind of elaborate.
Oh yeah, and people shouldn't be afraid to ask questions. I really don't bite, or at least not too hard. I totally agree with you in that because these systems have been constructed in such a way, and that we believe that it's normal. We really do. I believed it was normal when I was growing up. I believe that it was normal for Black people to be more like criminals. I remember I learned how to pick locks because I saw it on TV, and I was grade 6, and I learned how to pick locks until I realized there was a room that was locked, a storeroom at school, and we didn't have a key. And I go, oh, I can open that key. And just as I was about to stick that pin in there, I said, wait a minute. If anything goes missing from this room, I'm going to be blamed in the future. And I made that calculus quick. I was a smart kid. And I said, you know what? I actually don't know how to pick this lock. And I think that from that moment on, I decided not to play into those stereotypes. And so that created problems for me. If I ended up showing up, not to belabor it, but if I ended up showing up in math class and saying that to my math teacher and say, I want to take calculus, they were like, well, no, Richard, that calculus is too difficult for you. I think you need to go into like, the B side, right? Take easier math, and because you're playing basketball, Richard, you can't do calculus as well. So that stuff, I ended up having to fight that kind of stuff is when I was growing up. You're a smart kid, but people have expectations of you not to be able to achieve. So when I'm pulled over by a police officer, and it's not if, it's when, I'm driving a nice car, I have to make a calculus that when he sees me and he sees the hair, that he's got a stereotype in his mind about the kind of person that I am. So I have to talk as white as possible, as slowly and as clearly as possible. And I looked him in the eye, it's oftentimes a guy, and I explain to him and I ask him the right questions. I read his badge number back to him. I do all of those things to keep me safe, hands on the steering wheel, because I have to be on guard. So it's interesting to me, like what you said, the systems are all around us, and it forces us, many of us, to code switch all the time, or to be on guard all the time. And that creates stress and trauma for people. And so I understand when people fall ill. We have higher rates of infant mortality, higher rates of cancer, higher rates of this in Canada and the United States. But when we go to other countries like West Africa, where they have sometimes hunger and famine, they don't have those kinds of chronic illnesses, right? And they have McDonald's and Burger King too. So it's like, it's not that it's the diet, it is stress and the environment that we live in that's harmful to us. And that is underpinned by legal frameworks, it's underpinned by societal norms that we must change. One more thing real quick, and because I know, because the space that I've been working in is around data analytics, the human condition, both in Canada and globally. I know what's coming for Canada. Canada's future is Black and brown, and there's not very much people can do about it. I know right now we have preference for people coming over from Europe, from that, European tribal conflict. the future, the largest group of people that are coming into this country are people from the African country. Their continent of Africa will be the most populous place. People who look like me currently make up around 10, 11% of the global population. In 30 years, a quarter of the people will come who look like me will be coming from the continent. So that's going to cause an enormous pressure on Canada in terms of migration, because our populations here are shrinking. China's population is shrinking. India is surpassing China, right? Same with Europe. So the people that you need to keep your economy going are going to look like me. And you cannot with any kind of sense of self-preservation, treat people, the descendants of these people, like second-class citizens when they come here, or they will decide not to come, or they will not send their best, or when they're here, they will de-invest in this place and invest someplace else. I have to say that I'm in that mindset. I've been here for more than 55 years on this earth. And when I see my children are not being able to thrive, I'm looking elsewhere. And I will take all the resources and money and so on with me, and so will we, if it means that I have a better chance of life and prosperity for my children than to stay here in the country of my birth and be treated like this until I die. That's unacceptable. So if we want that change, I'm not the only one. There's so many others, especially professionals, that got to think about what's the future hold, and is this the right place for us? Policy, programs, basically basic human rights need to be respected in a way that safeguards our collective humanity. And that maybe is another discussion about that, because I think that this work is harmful when I'm being discriminated against, and white people and other racialized people are walking by. They own some of that, and my dehumanization means that they are basically being dehumanized as well. That guilt that can be so dangerous as well. But I mean, like, we have an opportunity here, a remarkable opportunity in this sort of historic moment where people were kind of woke, and woke in a real woke way, not like some of the conservative pundits have been so-called anti-woke movement. But woke means that you're aware and you respect other people who are different from you, and you understand the history around why things are the way they are. You're alive to the realities of their condition. But if more people are in that space, that I think we can actually achieve change.
Totally. And Richard, there is one more quick question, but before I get to that question, I think what you just said about this global competition for the brains, because we are living in an information technology, age of information technology, people across Europe are competing for the best minds. Canada, I think, will not have a choice but to, as you said, to relax rules, to treat people with respect and dignity, because otherwise, as you said, they'll pack their bags and go to Germany, go to other countries, especially in our technical kind of a world in which we're living, right? It's this globalized world, and technology and minds. These are what everybody on earth is competing for. So Canada will not have the luxury of cherry picking, because these people are going to pack their bags, as you said, and leave and go elsewhere. So yeah, I don't think we have that kind of luxury. One last question is what's the best way we as service provider for us to address anti-Black racism and anti-indigeneity within the community of justice programs?
Oh, that's a great question. The first thing you need to do is find out who the people are in those communities that you need to bring in to co-design and co-develop any policies and programs that are directed to those communities. If I sit in a room and I try to develop policies and programs for women, even if they're Black women, I'm going to fail. I don't know what being a Black woman or a white woman or any woman is like. So you need to bring them in. And when you bring people in the spirit of co-development and co-design, you have the possibility to create something special that you may not even have thought of possible. Because the energy of the people that you bring in, it's a big self-interest for them, for them to be there. That's the first thing that you need to do. Maybe the second thing, or maybe in tandem, is to educate yourselves on the issues that impact those communities in relation to your service provision. So whatever area that you're working in, how are Blacks and Indigenous people interacting with those systems? Do you have data that disaggregates the experiences of Black or Indigenous people? And can you use that data and that information to be able to come up with initiatives or directions or strategies to continually improve the experience? And I think that if you do those things in terms of bringing folks in from those communities, do some education work on your own or with others, and to develop metrics and data sets around that work, you're on your way. There's no stopping it.
Okay, so thank you, Richard. Amazing conversation. I think we need to have more of these brave conversations and courageous conversations. I think this is what will help, I think, all of us in the sense of, as you said, to humanize, both our mainstream white cultures as well as people with lived experiences who are on the receiving end of all of these institutional practices that are harmful, I think, to both of these communities. So thank you, Richard. I'm looking at the time. It's 10:30. I think it's time for us to maybe take a quick break. Darlene, I have you in mind in terms of your question. I'm not sure I can. I don't know if. Kathy, in terms of your question, if you could even maybe write something in the chat, your question, or maybe in the question itself, directly to our panelist. So for the rest of you, please feel free, take a break, stretch, get out, leave your room, walk around. I don't know, take a coffee, lunch break, whatever you want to do, a 15-minute break. Let's all come back at 11:45. Darlene, if you want to stay and post your question in the chat, I can pick it up and pass it on to the panelist, and then we'll kind of take it up from there. All right. So I'm going to stay for a few more minutes. For the rest of you, please, leave yourself logged on and just walk out and kind of. Darlene, you're still there?
Did Darlene have a question for me?
No, this was for the previous, I think,
Okay.
for the previous presenter. Yeah. Thank you, Richard.
Thank you very much for having me.
Thank you. So I don't know, Darlene, if you're still around, let me see if maybe just post your question. I can pass it on to the panelist. Sorry, we're running short of time, so that's why I'm kind of hurrying up. I just want to make sure that each speaker gets their time. So this is what's driving me in terms of the conversations.
Hi, Flora. Hi, Nicoletta. Flora, will you share slides?
I will.
That's great. I'll go off VPN now.
So we each have basically 10 minutes to talk, right?
Give or take, Nicoletta. I'll try to
Okay.
get through mine as fast as possible.
I always think I don't have enough, and then it turns out I always talk for way too long. So I'm gonna try and, I don't know, summarize what I wrote.
Okay, I'll try to be quick.
Same.
To set up. Yeah.
I mean, and also too, Nicoletta, like you're closing really. I see that we don't have a, I think you're closing, we're ending with that, at least in the current slides.
Yes.
So, and we're closing with the best part.
I'm so nervous.
So am I, Nicoletta. So we're all in the same boat. I'm always nervous. So you always are a good speaker though.
Thank you.
Yeah. Yeah. I see we don't have a slide at the end for the study, but that's okay.
Yeah, I mean, we can reference it in addressing any questions or.
Yeah. Maybe you can mention it, Arthur, at the end of yours. Do you mind doing that?
Yeah, okay. I'll try to remember to do that, and that'll be the transition to you.
Okay.
Nicoletta.
Okay. About mentioning the Q&A period?
No. I'll like before, like when I'm ending, I'll just say something about that we're currently exploring these because there isn't much on TBI and community supervision, right?
Right.
So we're actually exploring these issues in the study with our network. Sure,
just so you know, we just got something in the chat that people can hear us. So
yes. There's behind the curtain. It's like the Wizard of Oz.
So I'm gonna
Hearing
go on.
us is good. I do. Don't worry, we're not going to say, "Oh, why are we here?" Although I just did.
I'm gonna go on mute now.
All right. Okay. So Dr. Flora Matheson is going to be our next speaker. So a little bit about Dr. Matheson. Dr. Flora Matheson leads the Justice and Equity Research program located at the MAP Center for Urban and Health Solutions, at St. Michael Hospital. Her research focuses on solutions to reduce social and health inequities amongst people experiencing problem with gambling, imprisonment. Solutions are built with and for these communities. As a sociologist, she uses both gender and social determinants of health and lens to enact changes. So Dr. Matheson, please take over. The floor is yours. Thank you.
Thank you so much. It's a pleasure to be here. I'm just going to let my other two colleagues who are speaking with me introduce themselves as well. Nicoletta, do you want to introduce yourself?
Sure. Hi, I'm Nicoletta Curson. I'm invited to the conference by Justice Kofi Barnes. I'd like to thank him and the Association of Justice and Treatment Professionals. I've been working as a peer researcher on a variety of studies with Dr. Flora Matheson and Arthur, as well as the rest of the team that's not present today. And today we'll be talking about traumatic brain injury and conditions of release. Thank you.
I'm Arthur McLuhan. I'm a senior research associate on the team, working with Flora and Nicoletta and the rest of the team on these issues, important issues, an important stream of research around incarceration, health, and reentry.
Thank you. Okay, we're going to get started. I'm just going to share my slides. Just bear with me a moment. There, is that clear?
Yes.
Okay,
Yes.
great, thank you. So we're going to talk about traumatic brain injury and the criminal justice system. Sorry, my throat is bad today, so bear with me. I'll skip past these. We have 3 learning objectives for you today. We're going to learn about traumatic brain injury, its prevalence and risk factors for criminal justice involvement. We're going to learn about superdivision and conditions challenges for people with traumatic brain injury. And we're going to learn about the relationships between IPV and TBI in the context of conditions. I'm going to start us off for objective 1. We'll start with a definition. So TBI is a damage to the brain. It's caused by an external force, such as a blow to the head. It can be a penetrating force or a non-penetrating force. Likely causes of brain injury could be a fall, a motor vehicle accident, or a sports injury. We know that there are significant cognitive, behavioral, physical, and emotional challenges for individuals who've sustained a TBI, and TBIs can be anywhere from mild to very severe. And so the extent of the challenge that people experience or the symptoms depends on the extent of the damage to the brain. We also know it's a hidden or invisible disability. You can't see it on the outside, but it's there and it's causing challenges for people. There's no obvious outside or outward signs of disability, and the symptoms can be seen rather than as a disability, but as other illnesses. Maybe you may see people and think that they have a mental health concern, or it could be that we see it as character traits if someone is always aggressive. So keep that in mind. There are 4 major domains, symptom domains for TBI: communication, emotion, behavior, and cognitive cognition. Sorry. Under communication, there are things like whether people can listen intently to a conversation, and if they have problems speaking or engaging in conversation or thinking. In the behavioral domain, it's things like impulse control. Can they contain their emotions? Are there changes in affect? Like, do they have a heightened response to stressful situations, or they lack affect? They don't have a response at all. In terms of cognition, things like attention, being able to pay attention, be able to remember things, being able to process and reason. So these are all things around cognition that can be symptoms of a traumatic brain injury. And then finally, there's emotion. So heightened or blunted emotional response, or depression or anxiety. So living in the environment we do in the research world, we know that traumatic brain injury is very prevalent among people in jails and prisons, but not everybody is aware of that. But the rates are actually quite staggering. They actually do range. There's been quite a few studies done on prevalence, and they range anywhere from about 30% up to 80%. In one sample, it was 100% that was based on a particular set of individuals. But just to know that it's a very high rate in our prison systems, which means that we actually have people in the system with a health injury that is not being addressed. Okay. So just a little bit more on research. We also know from research that people in prison can have multiple brain injuries. So there's maybe not just one, but they may have several. We know that the counts are underestimated. My lab did a study with people who worked in the sex trade and with people who identified as women, and pretty much all of the participants had at least one head injury in their history, and quite severe head injuries. Many didn't seek help. Many didn't think they needed to seek help, but they also were uncomfortable seeking help because there's a lot of stigma associated with sex work and criminal activity, and also with drug use. And so the women really didn't feel comfortable in healthcare settings because there's a lot of stigma against them. Just tell you about a couple of studies that we did in Ontario. We did, this is with federal data, so people serving 2 or more years, sentences of 2 or more years. We looked at a cohort of men and women aged 18 to 28, so a very young cohort who sustained a TBI. We compared those with the same aged people, men and women, who hadn't sustained a TBI. Then we looked in federal correction records to see what the rates of incarceration were. And the rates of incarceration for people with TBI in this age bracket were 2.5 times more likely, greater than those who didn't have a TBI. So that's very striking. The rate of incarceration for people with TBI, especially in that age range, is a very young age, just starting out in life. And then we also looked at men and women 18 plus who sustained a TBI and who are in prison. So those who were in prison with a TBI and those in prison without a TBI. And we wanted to look at serious disciplinary charges. And we found that those with a TBI had 14 times more likely, were more likely to have a serious disciplinary charge. And so this is disturbing in the sense that those charges can lead to repercussions in terms of maybe sentence length, adding on to the sentence length, or not being able to meet parole conditions. So studies also show that TBI increases risk of return to custody. You can see the number here in this one study. And we also know that the Centers of Disease Control in the US, they've identified TBI among prison and jail populations as a significant public health problem and something that we should consider in Canada, but haven't done so yet. I just want to go over a little bit about women in the justice system with TBI. We know that approximately 70% of women in prison have a traumatic brain injury, and those who have, and women who are convicted of a violent crime, they're more likely to have occurred traumatic pre-crime, traumatic brain injury or some other form of physical abuse. So that's the implications of that are, concerning. And then women with substance use disorders have increased risk for TBI in comparison to women in the general US population. So we know that TBI is associated with a host of challenges across the domains we reviewed just a few minutes ago. These in cognition, emotion, behavior, and communication, and it makes it difficult for people in everyday social interactions. But what are the consequences of these challenges in criminal justice settings? Here, I'm going to read you a quote which provides insight into these challenges. So the trajectory of criminal justice involvement from interactions with the police, the frontline workers, probation and parole officers, to formal proceedings such as bail and court trials involves complex social interactions and, I would say, social communication that typically require high level and fast-paced processing of information, understanding and responding. So there are various concerns about when people come, for example, into a bail hearing or into a court trial and they have a traumatic brain injury, and maybe they can't process information quickly. The legalese in the courtroom is there's a lot of it, and even the general population often it has trouble following it. But if you have memory issues, if you have problems understanding social communication in everyday context, then those settings are going to be very difficult for people. It's going to put them in a situation where they may be agreeing to something that they shouldn't be agreeing to. Maybe they're going to plead guilty without really understanding why, what the implications of that are. So something to consider. And the last thing I want to leave you with, just for this little 101 on traumatic brain injury in the criminal justice system, is this idea of misconceptions of people with TBI in the criminal justice system. So those challenges that we've talked about, those symptom domains, think about that in terms of, meeting someone in the prison system who has a traumatic brain injury, and their behavior is different than what you would expect or what you would want in that behavior based on the rules and regulations of the correctional setting. So TBI symptoms can often be misinterpreted as non-compliance, rudeness, defiance, poor motivation, disengagement, and aggression. And all of these can create an even more volatile situation for the person in the criminal justice system, because their behavior is a result of a health issue, and it's not recognized as that. And there's also evidence that there's limited awareness and common misperceptions of TBI prevalence and challenges among supervision officers, and that may contribute to poor supervision outcomes. So with that 101, I'm going to turn it over to my colleague, Arthur, and he's going to talk you through supervision condition challenges.
Yes, I'm not sure if this makes it 102, but let's start with community supervision conditions, challenges, and those challenges in the context of having a TBI. Next slide. So community supervision in Canada. The number of individuals under community supervision exceeds the number in custody in correctional facilities in many jurisdictions internationally, including in Canada, where the number of adults under federal, provincial, and/or territorial community supervision is more than 2.5 times the number in custody on any given day. Although community supervision is intended to enhance reentry outcomes, providing a structured and guided, supervised reintegration, meta-analyses suggest that it has largely been ineffective in reducing rates of recidivism. Next slide, please. Next slide. Oh, sorry, there. Community supervision places people under restrictive conditions, such as orders to abstain from substance use, to regularly report to a probation or parole officer, to attend treatment, to find employment, to avoid particular places, geographical areas. Being under conditions increases the risk and consequences of accumulating further sanctions and returning to custody via technical violations and administrative charges related to failure to comply with conditions. Community supervision, scholars argue, thus functions as a net widening rather than penal reduction mechanism. So increasingly, scholars are arguing that we're moving from mass incarceration to a system of mass supervision, and the consequences of which are just starting to be explored. One of those areas that is a recent area of focus is how people experience and manage conditions, supervision conditions in their everyday lives, including the interactional work within social relationships required to manage the practical challenges of complying with conditions. So you may need to negotiate a relationship with the surety under whose authority you are staying by court order and abiding by those house rules. And you also need to navigate relationships with probation parole officers. Managing conditions is a complex social process involving multiple situated actors in the criminal justice system and the social worlds of those under supervision. The perspectives, practices, and interactions between those under conditions and control agents, such as police, judges, lawyers, probation, parole officers, as well as third parties, such as family, friends, and other community members. All of these relationships contribute to the experiences, trajectories, and outcomes of community supervision. And those actors and stakeholders operate in multiple as well as intersecting contexts: personal, social, organizational, institutional. And these contexts really shape the meaning and experience of supervision, how people approach it, how they approach breaches, how they approach sanctions. The fact that conditions, the everyday experience of conditions, is an interpretive, interactional, contextual process means not only that people define and respond to conditions in different ways, but also that these differences can reinforce inequality. The burden of conditional restrictions may be shouldered, for example, by those most vulnerable populations who will find making bail and meeting conditions most difficult. They also tend to receive, these populations tend to receive more conditions with higher levels of restriction, the terms of which often fail to take into account their context, social relationships, material hardships, health challenges, which prohibit their involvement with the very people, places, and things that had comprised the lived realities of these populations in dealing with disadvantage. The result of this lack of context being brought into informed conditions, the setting, applying, and enforcing conditions, results in poor condition-related outcomes, such as returning to custody, increasing criminalization and marginalization. And so, for example, there are some gender differences and dimensions to community supervision that are starting to be explored in the literature. Women who face incarceration experience significant social and personal challenges under supervision relative to men. For example, the typical incarcerated woman is a person facing mental illness, problematic substance use, economic marginalization, single motherhood, and a history of violent victimization. Increasingly more racialized women face incarceration, and women with relatively complex histories are more likely to return to custody for parole suspensions. Women's familial orientations and roles introduce competing demands during supervision as mothers, partners, providers, where these family reintegration efforts are contrary to or compete with supervision demands, expectations, and definitions of success. Next slide, please. Similarly, relationships with control agents are also important to women's experiences under supervision, with research indicating, for example, that the relationship style of probation and parole officers plays a role in women's success under community supervision. Women with a supportive supervisor experience less anxiety and have higher crime avoidance self-efficacy. For women with characteristics that predict recidivism, a supportive style is highly productive for crime avoidance and self-efficacy. Next slide. Although we know that there's a high prevalence of TBI among people who experience incarceration, much less is known about the TBI-related challenges and outcomes among people under community supervision, but it is an emerging area of work. There is strong evidence, as Flora noted, and as she has examined, that TBI history increases the risk for rule violation in prison, where people who have had a TBI relative to those without a history of TBI are more likely to be involved in violent and nonviolent behavioral infractions. such as refusing orders, possession of drugs and weapons, and incur serious disciplinary charges. Emerging evidence suggests similar challenges among those under supervision. Next slide. TBI is associated, as Flora noted, with cognitive, behavioral, and emotional and communication challenges that reduce the skills and capacities required to comply with standard conditions of probation, parole, and pretrial supervision, such as orders to abstain from substance use, attend regularly, remember to attend treatment, and to report to a supervision officer. TBI history is associated with greater risk of behavioral infractions, treatment non-adherence, and failing to appear for mandatory appointments, probation and parole violations, and revocations. Some evidence suggests also that limited awareness among probation parole officers also shapes this process. We are starting to, given the limited literature and research in the area, we are starting working with community partners. We have formed a Breaking the Cycle Solutions Network to explore and try to develop some sort of solutions to this issue. Our first initiative is a study called the Catch-22 Conditions of Community Supervision, in which we are qualitatively exploring the challenges of community supervision, the strategies for complying with conditions of community supervision among those with a history of TBI. So that work is ongoing, and if anyone's interested in it, they can reach out and we can share more about that study. Nicoletta.
Thank you. So I'm going to talk a bit about intimate partner violence in relation to traumatic brain injury and the criminalization of women. You'll be hearing me speak a lot about trauma over these next 4 days. So hopefully each presentation will be varied enough. So, you know, my talks don't become informal health breaks for you. So an overwhelming number of women experience intimate partner violence in their lifetime. TBI is a serious consequence of IPV that is often overlooked and misdiagnosed. IPV encompasses physical, sexual, and emotional abuse, as well as controlling behaviors. We already know some ways in which IPV might impact psychosocial factors. Many of the outcomes are, after all, predictable. Some of these are mental health issues, chronic or acute health problems, behavioral issues, substance use, police involvement, social isolation, neurological impairment, lack of effective problem-solving skills, poor educational performance, problem-seeking and maintaining meaningful employment, to which a criminal record, of course, contributes. So as some of you may know that I mentioned I am a peer researcher in the project, which means I do have lived experience with some of the things we are studying, including intimate partner violence, traumatic brain injury. So just to mention for educational performance, I went to university while I was doing my bachelor. It was shortly after this relationship ended, and it was extremely difficult, and I was trying to behave as if I were normal, whatever that meant to me at the time. I was just trying to do what everybody else seemed to do in life. And I began using substances as a coping mechanism. I thought this was finally making me feel like everybody else felt, which is not such overwhelming emotions that I can't deal with basic elements of existence. And I don't have a lot of time in this presentation, so I won't go into detail with many of the other issues right now. I'm going to move on to some aspects of IPV trauma. So I think a big one, I know for me, was anger. And I didn't realize that though, because I suppressed my anger, and it resulted in mental and emotional concerns as well as substance use. Other people have different ways of expressing anger. So this may be through aggressive behavior. Again, this can be a result of IPV. It can also be a combination of TBI and IPV. one of the aspects of IPV is disconnection and isolation. So as I'm sure many of you know, your partner slowly over time disconnects you from your family, your friends, until you are completely isolated and they're the only person you have contact with for the most part. And if you do have contact with anyone else, it's very often dishonest because you're trying to conceal the fact of what's happening to you in your relationship. So substance use, again, often becomes a coping mechanism to suppress anger, pain, trauma, flashbacks, nightmares, all the things. So because we're talking in the context of the criminal justice system, I'm going to talk about IPV and police reporting as well. So it is very unlikely that a victim of IPV will self-report her abuser to the police for a variety of reasons. I think fear of retribution is probably one of the main ones, at least it was for me. I know for other women, a major issue is family, CAS involvement if they have children, sometimes financial, if they're dependent on their partner. For me, definitely, though, it was the fear of retribution, because there were many times that there was police involvement, all of the times where somebody else made the call. One time, my father called the police. I did not share with him what was going on. I tried my very best to hide it from him. But one day he saw I had a bruise and he called the police, and they told him there's nothing we can do. He insisted, and so they called my abuser, who promised he would never do it again. And they called my father and said, oh, we had a conversation with him, you know, it won't happen again. And there were many, many other instances where strangers in the street tried to intervene, called the police, or also where my partner had an interaction with the police for a different reason. And I was there and they had an inclination of what was going on. Generally, that was because I would jump in and try to take the blame for whatever crime he was being arrested for, in order to, like, I don't know, prove my loyalty or trustworthiness or whatever it is I was trying to prove to him, so that I would have like respite from some of the abuse. And at no point in any of these interactions over 4 years was police contact helpful. It was my first experience with physical abuse. I was not abused as a child by my family. This was new to me. I was a teenager, and I didn't know that any resources existed at all. I did not know about domestic violence shelters. I did not know that you know, you could see maybe a social worker or psychologist to discuss this. Basically, I had no idea that any resources existed. I thought that the extent of it was, you know, you have to call the cops on this person, and the next day they'll get bail and, you know, physically abuse you because of what you did, and that it'll be worse. So I think one of the major things that can be done is this knowledge sharing, providing resources. Police are often the first point of contact for victims of intimate partner violence. And sometimes, yes, sometimes it's family and sometimes it's friends, though, like you're slowly being isolated from them and you're trying to conceal what's happening, really to protect them. Because I know for me, my friends were being threatened with violence, so I stopped talking to my friends. There were many times I tried to leave the relationship, and I I think I would have if it was just me that was under threat of violence, but then he threatened to kill my family. And because I was a young teenager, I believed that he would. So I thought, okay, I have to protect my family, my friends. And so it was extremely isolating. And so really, even though there is a lack of self-reporting to police, they generally have a good idea of what is happening, even if they can't actually lay criminal charges. So now in the context of IPV, TBI, and conditions in regard to the study, Catch-22 that we were discussing. So a lack of follow through with conditions due to TBI symptoms, such as neurological impairment or lack of insight into consequential behavior, has been mentioned by Flora and Arthur, but also conditions act as punishment or behavioral control, a deterrent to whatever criminal behavior has preceded the condition. But these conditions reinforce the abuser behavior, which is also a mechanism of control and a lack of self-determination. So conditions may also have implications for personal safety, such as having to have an address, a curfew. Your abuser, of course, will want to know these things, whether you like it or not, so they know where you are, when you are. Many of the times, at least in my case, but I know for a number of women, often they do have a male co-accused. Sometimes this male co-accused is their partner. Sometimes this partner is their abuser. So you are not allowed to have contact with your co-accused, but if you lack control over your own decision-making process of who you can and cannot see, whether you engage with your abuser or not, is not up to you. And so that you're implicitly, or you're being dragged into not following through with a condition and then ending up being, once again, punished by the system for this thing that you don't really have control over, or at least feel that you don't. So I would like to spend some time before we go into the Q&A on suggestions. I think for me, this is really the most important part of this presentation. And so some of the things that I think are important to do are taking an interdisciplinary paradigm of legal treatment and social services when responding to criminal charges against victims of intimate partner violence, or when police contact is initiated with potential victim. So whether it's in the context of the victim having committed a crime, maybe with the abuser as co-accused, or simply police contact in any other way where that dynamic is at play. So providing accessible resources to the victim that are either immediately available or available at a time when the victim chooses to engage with those resources. I know many of the times, all the times really, that there was a police contact where my partner and I were present, and there was the question of, do I want to report the physical abuse that I didn't admit to, but that the police, said they knew was occurring. So they would separate us a little bit. One police officer would be talking to me, and like a few feet down, another police officer would be talking to my partner. And really, it doesn't feel supportive of safe. It doesn't feel that, okay, if you do go ahead with self-reporting, you're going to be safe. So I think more needs to be done in this realm, where maybe it's not just the police that have this initial contact. Maybe when you're pulled away from your partner, there's some intervention with either social services, mental health professionals, some sort of treatment team, other than just a visit to the ER where you're in and out. So again, just to reinforce, providing resources. And so I think also, because self-reporting is extremely low, adopting default suspicion of abuse by legal and treatment professionals could function as an intervention tactic. Honestly, people are quite good at reading a situation, even if you believe, like I believed I was hiding it well. My partner believed that nobody would suspect him of being abusive, but actually it turns out that everybody actually knew what was going on, regardless of my multitude of excuses. So during this conference, there will be much discussion about the need for trauma-informed approaches in the justice system. This is because we as a society have become aware of the structural violence inherent in systems. So incarcerating victims of IPV and TBI reinforces trauma, marginalization, and stigmatization in an already disconnected and isolated population. I think judicially supervised treatment, like we have for drug treatment courts, mental health courts, as opposed to incarceration for current and former victims of IPV, would be of great impact and offer support to people who generally lack support. So I just want to provide a quote by Marshall McLuhan. He once wrote, "We look at the present through a rear view mirror. We march backwards into the future." He was, of course, talking about the medium of media, but also the influence of environment, the environments that we create in our societies. So let's think of the legal system and incarceration as a medium. We have had the past 130 years since the establishment of the Canadian criminal justice system and the founding of the first Canadian penitentiary in Kingston, to come to the understanding that punishment is not an effective tool for creating healthier societies, that jails do not effectively reintegrate incarcerated individuals, nor do they discourage recidivism. If anything, I believe they contribute to recidivism due to institutionalization as a chronic biopsychosocial state. So perhaps it's time we turn around and march forward into the future. Thank you.
Wow, amazing, amazing presentation. I'm just going to look, see if there are any questions. I think hopefully the volume was resolved. I think there was just one question. So for those who have any questions, feel free, raise your hand and click on that reactions button. And when you click on the reactions button, it is the reactions button. When you click, there's a raise hand feature. If you want to click on the raise hand feature and kind of ask any questions that you may have. But for me, my take, I think this, number one, I think this is an excellent teamwork. Dr. Matheson, Dr. McLuhan, and Nicoleta, hopefully I'm pronouncing your name correctly. Thank you for sharing these stories, because I think this is what humanizes the system, right? This is where I also teach social policy, and I tell students, there's hot knowledge and then there's cold knowledge. The hot knowledge, the cold knowledge is the knowledge of the textbook, college, universities, PhD. The hot knowledge is the knowledge of the lived experiences. And if you really truly want to make any policies inclusive, you need to combine the hot and the cold. And this is how you kind of create more inclusive policies, inclusive programs. And so this, I think, is an amazing kind of teamwork, in terms of, Dr. Matheson and Dr. McLuhan's research work, and Nicoletta, your lived experiences and how they all kind of intersect with each other to create policies that are humane, to create institutions, laws that are humane, that takes also into consideration the knowledge of the lived experiences. And for us, I think maybe as university educated, to kind of, for timing, park our expertise hat and kind of look and use other lenses to look at the very same policies. So amazing. Thank you. I don't know how else I can thank you. I think this is amazing that you're able to put all the research as well as the lived experience, and this is the result of what you're hearing and seeing. Let me see if there are any hands up, any kind of questions, any comments anybody has. Unless I'm thinking maybe people are just hungry and kind of want to take a quick lunch break. But yeah, thank you. I'm also looking at the time. We are on the dot, 12:25. So let's take a quick a lunch break, 12:25, and we will come back at 2 p.m. And once again, Dr. McLuhan, Dr. Matheson, and Nicoletta, thank you for this amazing presentation.
Thank you for having us, and I apologize if my video won't come back on, but thank you very much for having us.
Thank you. Amazing. So you please switch off your cameras, take a walk. I think I'm going to do the same. I got a park across. I'm just going to take a walk or something. Let's all reconvene at 2 o'clock. Please be logged in. Don't go anywhere, and we'll reconvene at 2 o'clock. Thank you, everybody. Hello, hello, hello. Welcome back, everyone. So hopefully you've had a good long bit of a long kind of a break, long break. Sorry, what am I saying? So welcome back. So let's get started. The time right now is 1:59. So in about a minute, we'll get started. For those of you who just joining us, welcome. For those who are already here, thank you for staying and say thank you for being here. So what we'll do right now is Justice Judge Murray Hines. Hopefully, Judge Murray Hines, I'm pronouncing your name correctly. A little bit of introduction. Judge Hines has been serving as a judge in the Provincial Court of Saskatchewan for 14 years. During this time on bench, he has presided over Drug Treatment Court in Regina, Moose Jaw for about 12 years, and Mental Health Court in Regina. So, Judge Hines, please feel free, switch on your camera and take over. And thank you for being here, and thank you for your presentation.
Well, you're welcome. Can you hear me or see me?
We can hear you, but we cannot see you, Judge Hines.
Okay, maybe I'll push this button here.
Yeah, so at the bottom, you will see a video camera. If you can click on the video camera, hopefully. Oh, there you are. Thank you. Amazing. Nice to see you, Judge Hines. Take over. The floor is yours.
All right. Well, thank you. It's a great pleasure for me to be able to present to the group today. I've been involved with therapeutic courts for a good long time, and I'm very excited about them because I think they're a great benefit to the people that we serve. And it makes our community safer when we do things right in the therapeutic courts. Just by way of background, in Saskatchewan, there are 7 therapeutic courts. We have 3 domestic violence courts, one in Battleford, so North Battleford area, that was started in 2003. One in Saskatoon that began operating in 2005. And one that began operating in Regina in 2008. We have 2 drug treatment courts, one in Regina, a federally funded model, which is the Cadillac version of things often compared to lesser funded. We also have, and that began in 2006, and then we have Moose Jaw Drug Treatment Court that began in 2009, and it is not federally funded, but the province assists us in our efforts. And then in 2013, Regina and Saskatoon Provincial Court began their mental health court, and they've been going since. Now I'm going to try and share with you a little PowerPoint. Is that available to be seen?
Yes, of course. Yeah, Judge Hines, click on the share screen button, open your PowerPoint presentation, and then just click on the share screen button. It's a green color button. If you click on it, you'll be able to share your PowerPoint presentation. The green color right at the bottom row, the bottom row, where you clicked on your camera, there should be a green button that says share screen.
Oh, yes. Okay.
Yeah, so just click on it. And I mean, first you have to open your PowerPoint, and then you click on the green button. And once you see your PowerPoint, double click on it, and all of us will be able to see it.
Is that up and running?
No, not yet. We still cannot see the PowerPoint. No. So yeah, I guess first you will have to open the PowerPoint presentation and then click on the green button.
Okay, well, the PowerPoint is open.
The PowerPoint is open. Now click on the green button, and when you click on the green button, you will see all your opened applications, all the open files that you have, and one of them should be your PowerPoint. Double click on the PowerPoint.
Well, you know, I don't think it's going to work. So
Okay. Do you want
I
to
won't
just
be-
talk instead?
I'll talk instead.
Okay. All
I
right.
don't want to be distracted from what we're doing today. In addition to the 7 therapeutic courts we have in Saskatchewan, we're hoping to add a drug treatment court, probably in the Battleford area in the near future, as well as the domestic violence court, hopefully in Yorkton, Saskatchewan, in the near future. Now, today I wanted to talk about the rather exciting topic of governance structure for these courts. Why? Well, because our experience in Saskatchewan was that, and this is common, I think, is that individual judges took an interest in different therapeutic courts and then began them. And it was often a community and local judge initiative. And we started having different therapeutic courts pop up, so to speak. They didn't really pop up. They were planned. They take years to plan, and they came into being. But in 2018, the various therapeutic court teams from across our province and other key stakeholders came together and had a 2-day in-person session to exchange knowledge and have strategic discussions about therapeutic courts. And one of the immediate results of this really important meetings was that the Ministry of Justice in our province was tasked with developing a governance structure for therapeutic courts, something they readily took on. And in 2019, the Therapeutic Courts Oversight Committee was formed, and it was to set provincial standards and to provide oversight of the therapeutic courts in Saskatchewan. This was important for a number of reasons, not the least of which is other communities were interested in developing or opening a therapeutic court, and the idea was to assist them in doing this, giving them some guidance and direction. Now, the membership of this Therapeutic Courts Oversight Committee included a member of the judiciary, who happened to be myself, and then we had a host of others, including we had an Associate Deputy Minister of Justice from our province. We had a Director of Therapeutic Courts from Justice. We had the Ministry of Justice Prosecutions person, senior official, Ministry of Justice senior official from Victim Services. And then we also had essentially, well, we call it Community Corrections and Policing, or otherwise known as probation, senior executive, as well as the CEO of the Legal Aid Society. We also had Municipal Police, Regina, Saskatoon, and RCMP, senior representatives. Also, Ministry of Social Services, because a number of our clients depend on income assistance. And then we had Ministry of officials from health, mental health and addictions, Saskatchewan Health Authority, mental health and addictions, as well as the Public Prosecution Service of Canada and First Nations Inuit Health Mental Wellness Program. So that's who began that work in 2019. Now, the purpose of the committee, the Oversight Committee, was to set provincial standards and provide oversight of these therapeutic courts in Saskatchewan. And we had several goals in mind, which we've been working towards. One was to assist therapeutic courts and communities who are interested in establishing therapeutic courts. 2 was to identify and promote the use of best practices in our therapeutic courts and actions supported by evidence-based research. 3, identify data needs and promote the evaluation of therapeutic courts to assess their impact on the criminal justice system and the communities that they serve. And then also, of course, to ensure that the therapeutic courts, whether they be a domestic violence, a drug treatment court, or a mental health court, were actually meeting the needs of the people appearing before those courts. Now, we had various roles and responsibilities set out. But first and foremost, we wanted to develop a provincial strategy for these therapeutic courts in Saskatchewan, develop, as I've said, these evidence-based provincial standards, and then make sure that there was coordination and provision of resources to therapeutic courts. And of course, an important one, as we're seeing today, is identifying educational opportunities for our team members and actively encourage and assist team members to attend educational events, such as the one they're attending today. We also, of course, are going to oversee the expansion of our existing therapeutic courts and working with communities and making available resources from various ministries at the community level. Also a part of it, is anyone familiar with therapeutic courts is concerned, is developing and implementing data collection and evaluations of therapeutic courts. And then, of course, actually communicating with the various therapeutic courts on a regular basis. And if necessary, provide some direction to local governance committees on issues or challenges that may arise. And lastly, we wanted to be a repository for existing protocols of each of the therapeutic courts. And this is some of the things we went about doing. So to date, our Therapeutic Courts Oversight Committee has completed a number of tasks. And one is setting out a governance structure. And if you can picture this, I'm sorry my slide isn't available for you to see, but we have this oversight committee at the top. Below that is we have local advisory committees for each of our current 7 therapeutic courts. And then below that is each of our 7 therapeutic courts. There's a two-way communication lines between all of these so that it's not a, while it looks like a top-down sort of structure, there's communication between each level. Now, we also set out our vision, our mission, values, and principles, which we developed, which I'll come to. And then some of the bigger work was on providing an overview and standard documents for each of the domestic violence courts, the drug treatment court, and the mental health courts. And so, to be clear, for domestic violence, we had one overview and standards document for all of them. We had one overview and standards documents for drug treatment court, and one overview and standards document which we developed for mental health court. As well, we created planning documents for each potential new court that wants to develop. So if a community said we'd like a domestic violence court, these planning documents set out who should be involved at the local level and what sort of steps they have to take in order to begin their planning for a drug treatment court, a domestic violence court, and a mental health court. And interestingly enough, it's been our experience that it takes between 2 to 3 years from the beginning of the community being interested in one of these courts and to its actual implementation. So the planning document helps those communities working with their judges, usually a judge that takes an interest in the local community, senior crown, senior legal aid, and of course then the very probation officer, and then treatment providers from within the community. And then finally, the other thing that the Oversight Committee has done is updated the content of our website regarding therapeutic court. And that's been a big task. And all of these other things that I spoke of, the planning documents, the overview and standard documents, even the structure that I've talked about for the governance is all on our website. And this is a big part of our communication piece. If people don't know what you're doing or why you're doing it, it's hard to get much public support for these things. while you might be well regarded within a small sphere, the idea is to make sure that we're accepted within our community and within our province, and that we tell people what we're actually doing. Now, if your province doesn't have a therapeutic courts oversight committee, you may have a different way of approaching this, but we found that this is working for us because we pull together a large number of senior people at perhaps a higher level, overlooking things and communicating with one another. And then we're greatly assisted by our Director of Therapeutic Courts, who's with the Ministry of Justice, Dawn Anderson. And Dawn plays a very vital role in that she is really the repository for most of this information. She also is a liaison between the Oversight Committee and the local city to see what issues may be the local. And the idea, to be clear, is not to get involved with day-to-day operations, but if there's problems, challenges, obstacles, this is where the Oversight Committee can assist, particularly at once these if it can't be solved at a lower level, at the level of the actual therapeutic courts themselves, or at their advisory committee level, then the idea is for the Oversight Committee to assist in this regard. Now, in terms of our vision for our overall therapeutic courts in Saskatchewan, it is as follows. The Saskatchewan people are safer through reduced victimization from drug, domestic violence, and mental health related to crime by helping offenders change their behavior. And our mission, and this would be probably something I would expect to all relate to, is integrating justice, probation, treatment, health, and social services to empower offenders with substance use disorder, domestic violence behaviors, and mental health challenges to become non-offending, healthy, and productive community members, and this is particularly important, to provide victims with better support. And this is particularly so certainly in our domestic violence courts. Victims are taken into account there. There's a great need for communication with victims to let them know what's going on, how the case may be progressing through the court. And often, of course, we see at the domestic violence courts, there's always a need to address the desire to lift no contact conditions. So we have a process for no contact assessments. And usually we go about that when they've entered the program, the treatment option, provided they have. Then as they move through their treatment, there usually is a graduated approach to the non-contact condition. It may start, for example, permitting a phone call. The phone calls may then graduate to perhaps a texting is permitted, provided other underlying issues are addressed in the further along in the program. It may relate to limited contact. That may be a third different location. There's always issues around exchange or access to children, but it's a graduated approach, and with the involvement of the victims all along the way. One of the important things, at least with respect to our domestic violence court, which I can speak of, is, and I know there is a debate about this, we require to be part of the program a guilty plea. And we also require at the early stage of proceedings, when the guilty plea is entered, there's an agreed statement of facts that is worked out between the Crown prosecutor and the defense lawyer, often either way. That's put in a sealed envelope, and so that when we get to the completion of the program, months, perhaps even a year down the road, there is an agreement upon what the facts were given rise to the offense. And then, of course, these models sentencing. I just wanted to briefly speak on a couple of other things today. In terms of these overview and standards documents for each of the domestic violence, drug treatment court, and mental health court, and planning documents for each, the easiest way to find this information, which we publish, is go to Courts of Saskatchewan website, and that will list the provincial court, the Court of King's Bench, and the Court of Appeal. We're the people in blue, the provincial court. And if you then go under that, you can go down to the therapeutic courts, open that up, and you'll come to all the information I've referred to here in terms of the therapeutic courts. And these documents are quite detailed, and they will be revised from time to time. But they sort of set out our overview of the program, the standards, and then, of course, as I mentioned, the community is looking to develop one of these courts with planning documents to assist them in their endeavor. We're trying to help people along so that they can achieve what they want for their community. Now, the last thing I wanted just to say is there's 6 common features to therapeutic courts in Saskatchewan. And these would, I'm sure, resonate with many of you. We have a multidisciplinary team working collaboratively. Of course, we have, and part of this is having dedicated people. We've found over the years that you can't have rotating people. That is, you need a dedicated judge who sits in these courts 2 to 3 years. But you can't have a rotating situation there because of the you get to know these people and they get to know you. You develop a trust or bond when it's done right. And there's a style of communication that occurs in the court that only happens when there's that, I think, relationship that's established. We also have dedicated prosecutors and duty counsel, which in our case could be delayed, although lawyers are welcome. Usually, although it's left to our duty counsel to provide it through the delay. And then the other, of course, important critical members of the team have mentioned probation services, but then the treatment provider, whoever they may be in the local community, and these can be counselors, they can be a nurse, say in a drug court, they can be an elder, sometimes elders are involved in these processes. And of course, the multidisciplinary team has to work together, usually led by a judge. We all, the other common features are eligibility criteria and referral process, which is common to most these courts. We have a deferred sentencing model, which I've referred to. And then we have required programming. And then, of course, the 5th is monitoring of people's compliance and progress through regular court appearances. And then lastly, and most importantly, is the stabilization of the individual in the community, and then sentencing takes place, hopefully preventing the reoccurrence of the problem in the future.
Yeah. So, so Justice Hines, thank you. I've also posted the link. I just Googled the Saskatchewan Therapeutic Court, and I found it. I posted the link for our audience. And thank you. You know, for those, I think, who are listeners, you know, that's the website. And Justice Hines, would there be a contact information for you, Justice Hines, if anybody wants to contact you and set up something or get some knowledge, some information?
Sure, you can just contact me at mhines, H-I-N-D-S, at skprobcourt.ca.
Okay, all right. Okay, so thank you very much, Justice Hines. Thank you for that amazing presentation. I just, you know, getting such a large team together and kind of coming up with a plan, I think it's a really kind of a huge kind of a project to get everybody on board. But I think it also, you know, speaks to that human beings are whole beings, and we cannot just say this is the legal part and then this is that, and then kind of having these holistic approaches, I think is marvelous. And the way you described it is bringing these team together, I think was amazing job to kind of get them all together. So thank you, Justice Hines. We have Marie Dufort. Hopefully I'm pronouncing your name correctly, Marie, or I'm not mutilating your name. I beg for your forgiveness if I am. Yeah, so Marie, the floor is yours. Marie is the Assistant Crown Attorney, Ottawa Crown Attorney's Office. Please.
Yes, good afternoon, everyone. So I have been with the Crown Attorney's Office for over 20 years, and I'm both the dedicated drug treatment court Crown for Ottawa, as well as the dedicated mental health Crown. I'll speak a little bit about our drug treatment court mostly, and a little bit about how this regroups for some of the participants in a more integrated approach with the services that we can offer in mental health court. When I was asked to speak about the why, the how, and the impact of the Ottawa Drug Treatment Court, I thought I would focus a little bit more on the most recent years. Our model is based on the we've had our drug treatment court operating in Ottawa for 17 years, a little bit more than 17 years, since 2006, and our court is modeled on the Toronto Drug Treatment Court model that started some years before in '98. We are also a problem-solving court. We remain so to date. Our court is mostly a collaboration between community partners, our treatment provider, which is Rideau Wood Addictions and Family Services, the Public Prosecution Service of Canada, and the Crown Attorney's Office. We have dedicated duty counsel to our drug treatment court, and also we have a dedicated probation officer. We also have a collaboration with our local police service, and we have rotation of dedicated officers who are assigned to our drug treatment court. Our court is a non-adversarial model, and it offers a therapeutic rehabilitation program. Obviously, the participants need to be willing participants. They need to be addicted to drugs. And we target our court for non-violent offenders. Obviously, it's an alternative to incarceration for the most part. We have one model. We've had two models. I'll speak a little bit about that. We have a regular model, which usually has a minimum of a 9-month participation. It's in two phases. We have a higher intensity phase initially that sees participants involved every weekday, 5 days a week for individual and group therapeutic endeavors, as well as individual counseling with their case manager. And they can successfully then move on to a second phase where, although they maintain this therapeutic and rehabilitation contact with the treatment provider, they can reintegrate the labor market, further their education, and solidify their assets in the community to ensure a smooth transition back to a productive life after they finish the program, which is obviously the court-directed program. Right before COVID hit, we had created a pilot project, which we call the EIDTC, the Early Intervention Drug Treatment Court. This was concerted effort to try to address individuals who had an interest in participating in this court-directed drug treatment rehabilitation program, but that had less contact with the criminal legal system, offenses that tended to have a resolution position from the Crown that did not involve incarceration or a short period of incarceration, where obviously the balancing act and the interest of participants to participate in a longer drug treatment court model of a minimum of 9 months was not something that was considerable. In that, our model was a 16-week minimum program that basically allowed participants to continue with either education, work, and also saw them having contact with our service provider, but at a frequency that was less than the regular model. This started in 2019, so right before the pandemic hit, and the measures that were taken, including not having in-person court. We have discovered that although the criminogenic factors were less and the contact with the criminal legal system was less, that did not translate in the therapeutic needs being less. So right now, and because after, more than 17 years, when you have a house, you look at renovating, refreshing, and always keeping it current. We have stopped our model of early intervention drug treatment court as a program, as a separate program itself, and we're more looking right now at a case-by-case basis and how we can integrate these individuals in the model that we already had in existence and addressing their needs that way, albeit probably for a shorter period of time. The persons who are and were targeted and are still by our shorter early intervention model are persons where the result often is either a diversion, conditional discharge. That's mostly what we target in the early intervention drug treatment court. We are looking at the way we look at our integrating our programs, and the currency of our program is we also have a policy committee as part of our renovations of our DTC house in Ottawa. We are doing a constant and a full review of our policies and our procedures to ensure that they remain in line with our treatment goals and orientation handbook for the participants, and that our release conditions are something that is conducive to treatment, and also ensuring that the participants can participate in various therapeutic endeavors. Our policy committee ensures monthly that we have monthly team meeting where we address concerns, innovation, and a necessary review. The goal is to do that as swiftly as possible to ensure that the program really addresses the needs of our population in Ottawa, and also in keeping with the goals of this court-directed program. In our policy meeting, we maintain a partnership between various actors in our program, prosecution services, the bench, treatment providers, and also community agencies. We strive to have a consistency in the approach, and this is both at the policy committee meeting and the weekly court appearances and program. We have a dedicated team, a court team, and roster of dedicated prosecutors to the drug treatment court. We have dedicated team of judges as much as possible. And we also have a dedicated probation officer and duty counsel. Our model still targets non-violent offenses for the most part. We do not accept residential break and enter. Obviously, we'll look at a case by case in terms of common areas in residential buildings, such as laundry room, mail room, garage, storage units. We do not accept driving offenses. We have expanded our model. Again, it's always on a case by case basis in terms of adapting to the currency of consumption of drugs, especially fentanyl. Now looking at, again, always on an individual case review, but looking at acceptability of sub-fentanyl trafficking cases in the drug treatment court. We've adapted over the years when fentanyl became more prominent. Possession for the purpose of trafficking of fentanyl was not something that was looked at to be accepted in our therapeutic model. It is now something that we accept when the case is conducive to this therapeutic endeavors. And that's in keeping with our review of the evolution of addictions in our community here in Ottawa, and really to respond to the needs of our population. Our model works on an acceptance of an application in drug treatment court and a review by both the court team for suitability and then for looking at an intake phase where the person is screened for suitability by the treatment provider. We've discovered, and that came probably more to light since COVID, that there are some needs and of the participants that really needed to be addressed during this intake phase. The persons needed to be supported. Sometimes the intake has been taking a bit longer, still with some pandemic restrictions that remain at the local detention center. And we felt that some of the participants need more support to be able to succeed through this phase. Also with participants that are out of custody, and ensuring that they meet at the meeting time and they don't miss assessment meetings that are really essential for finding suitable housing, also with community partners, ensuring that they can integrate the drug treatment court therapeutic model without unnecessary delay. We've discovered that some individuals had more difficulty. Those often are some individuals who have concurrent disorders. We are fortunate in Ottawa, as in I'm sure in many other jurisdictions, that we have a dedicated mental health court where we also have quite a number of community partners. When I indicate that we're lucky, we work in concert between the community partners, and we have developed even more recently, really focus on a more integrated approach to offer mental health support, and the supports that can be offered from our mental health court model in supporting participants who are mostly at the initial phase and the assessment phase in the drug treatment court. Once they are more into the program, this initial phase has been completed, often we find that the supports might not be as necessary, and some of the community partners from our mental health court might then take a back seat a little bit and favor this approach between Rideauwood, our community partner for drug treatment service, and the participants. We've found also that on some occasions recently in our renovation of our house, that having a person supported by probation services is also something that might be very beneficial. So we have looked at resolving some offenses prior to this initial phase in the drug treatment court for the person to be put on probation and have this additional support to ensure that they succeed in their endeavors. Also, of course, this is something that's looked at depending on the case and the needs of the person. But it's been highlighted significantly through COVID and since then, since we've resumed more in person, that the needs of our participants might not have been entirely met without this additional support from other therapeutic partners. We have not in Ottawa stopped drug treatment court even since the pandemic started. We moved to an online model without missing a week. This is mostly due to our court, well, to our judge responsible mostly for drug treatment court, who has swiftly embarked on adapting to a virtual world. And I think that really served to support our participants, and the program continued with adaptation all the way up to resuming gradually in person, first at the treatment provider, and since earlier this year in person in court as well. We have had graduations, and quite a few during the pandemic. Some were done virtually and some resumed in person. There's been great successes from our participants, and some participants have truly embraced their DTC journey and have been able to give back to our community. We have one participant who had quite a lengthy journey in drug treatment court, and not an easy one, but who has graduated successfully during the pandemic restriction and has given back to the community by starting a pet food bank, gathering donation and distributing to those who, are really feeling the pinch of the difficult economic times. And I think that's truly a testament to the impact of this DTC program, and really the pulling together of all the community partners during these difficult times. And also it's still an adaptation period right now that we're back in person, but I think it's really a testament to the fact that we have a very strong, I think, partnership in Ottawa, and we really strive to ensure that we remain current and that the program is adapting to the needs. We also have, and I know my time is running out, we also have a therapy dog program in Ottawa. And that the purpose of this program is, I think, to build a bond between the participants they come during the weekly court appearance for the participants, now in person. And it really serves to alleviate some anxiety and fears of individuals, as you know, who have been in court in more adversarial appearances before and have this reluctance and fear of the court process. I think it's bringing these participants together in a little enterprise, which is to receive the love of these therapy dogs, calming anxiety, and also for them to form a bond around these little partners that we have to ensure that this more formal, especially since we've been back in person proceeding, is done in a way that's conducive to continuing their therapeutic endeavors. And I know I'm looking at the clock, I'm running out of time, so I think I'll leave it at that. I think you.
Yeah, sorry,
Okay.
I'm talking to myself. This would never happen in real life, but I'm talking to myself. Marie, thank you, thank you, thank you. I think especially in the light of all the previous presentations we had, from a trauma-informed perspective, when people come with trauma and then they meet persons like yourself and your program, I think that takes care of that. I'm the frontline worker. I do addiction counseling as a social worker. So for me personally, it's heartwarming that there are people at the other end of the the other end, that persons like yourself and many others, I think, here, caring individuals that are there in this attending these conference. I think it's heartwarming that there are a lot of caring individuals and programs that are out there looking out for and trying to address and meet the needs of the client. So thank you, Marie. Thank you for that amazing presentations. Really well done in the sense of the kind of services that you laid out that are available for I think it's the same client that we service. You and I, it's the same persons that go around and around kind of in circles. So thank you. Thank you.
Thank you for putting on this very interesting conference.
Yeah, thank you. That's amazing. So maybe we'll, in the interest of time, let's move on to our next speaker. Our next speaker is Dr. Sorry, what am I saying? I just read the D and said Dr. Judge David Orr. Judge David Orr started his legal career with Department of Justice in Newfoundland as a Crown attorney, and then entered private practice in 1981. While in practice, he chaired Legal Aid Appeal Board and the Criminal Law subsection of the CBA. He was a criminologist instructor at the Memorial University from 1981 to 2011, and bar admission courses instructor from 1995 to 2023. That's today, this current year. He was involved in design and implementation of mental health court and drug treatment court in St. John's, and has presided as the judge of the mental health court from 2005 to 2023. Again, that's current year. In the drug treatment court from 2018 to 2023. Yeah, so the floor is yours, Judge Orr. Take it.
Okay, well, thank you very much. I do have some slides I wanted to share, and let's see if I can get them. No, it's not them. Hang on. Let's see. There we go. All right, and should go. There we go. All right, so the as was mentioned, what I was going to do is just briefly give an overview of what we're doing here in St. John's.
Hi, Judge Orr. We can
Yes.
see your next present. Put it in the presentation mode, because I can see both of your next slide in this. If you put it in the presentation mode, then we'll only see one.
Oh, okay. Well, I have no idea how to do that.
Okay. All right. So at the bottom, you will see a presentation, a screen. If you click on that at the bottom of your PowerPoint slideshow.
Okay.
If you hover your mouse cursor on the thing, it will say something like a slideshow at the bottom, you know, where you have your, if
Okay.
not, it's okay. Try that, see if that works. If not, otherwise we can see your notes there, and but if not, that's okay too. Or click on the presentation, the big screen presentation kind of thing.
Oh, what over here? That's the next slide.
No, nothing has changed. It's fine. Just continue. It's okay in the interest of time.
Yeah. Sorry.
Yeah, let's just continue it. Yeah, that's no problem, Judge Orr. Thank you.
Okay. Anyway, in relation to that, have you seen that slide?
Oh yeah, we can see the slide. Yes.
Okay. The drug treatment court was started in 2018. It was designed as a collaborative project between the provincial court, the Newfoundland and Labrador Legal Aid Commission, the Department of Health, Community Services, and Public Prosecution Service of Canada. So it's a federally funded program. We already had two other therapeutic courts. We had the mental health court, which we started in 2004, and the Family Violence Intervention Court started in 2009. They're all based on the same therapeutic model and therapeutic basis, and they all have somewhat similar procedures. There's a quote that I like in terms of the overall philosophy behind it, and this is from Richard Snyder's book, and he talks about therapeutic justice in terms of it focuses on the law's impact on emotional life and on psychological well-being. It views the law not as being neutral. The law and legal rulings have an impact on the accused, humanizing the law and concerning itself with the human, emotional, psychological side of the law and the legal process. So it's a different way of thinking about it. And what the idea is that the court is designed so that it's predicated on the relationship between the accused essentially and the judge and the treatment team. And it's a therapeutic and supportive relationship, which helps them to develop a strategy to meet the challenges that's brought the accused in conflict with the justice system. So it is a step out from the traditional adversarial approach, which I'm sure that everyone is familiar with. The eligibility criteria for our court, it's an adult court, so you have to be 18 years or older. You have to have an addiction to drugs, either scheduled or not, but cocaine, methamphetamine, opiates, or prescription drugs. And there has to be a willingness to plead guilty and acknowledge responsibility. Now, not all therapeutic courts are set up with the guilty plea at the early part of the process. The mental health court doesn't do that, actually. The mental health court puts the guilty plea at a later stage. But the model that we're following is predicated on a guilty plea then the accused is on judicial interim release pending a resolution of the charges. The offenses that we're accepting have to be motivated by drug addiction, committed primarily to support drug addiction. They have to be nonviolent, and the accused has to have no recent significant history of violence. And you have to be within the jurisdiction of the St. John's Court. The reason for that is merely logistical, in the sense that you have to be able to attend court once a week. You have to go to the random urine screens, and of course, you have to meet with a therapist. Our therapy team is attached to the court, and we have a dedicated addictions counselor. Some charges that are not eligible, and these are the ones that are associated with violence, armed robbery, break and enter, personal injury, trafficking in drugs solely for profit, those involving youth or youth at risk, those involving drug impaired driving and related gang activity or organized crime. Now, as I'm sure everyone will recognize, that comes from the federal funding for the court, which it's predicated on. And so that's why the exclusions are there. That does have the effect of narrowing the net. What we have done when we're able to is sometimes you can deal with the facts of a particular incident where you can redefine the offense. So rather than break and enter, you can charge unlawfully in a dwelling or malicious damage or something to that effect. And that's what we're really trying to do, because we're trying to be as inclusive as possible. Personally, I think it's unfortunate that some offenses are excluded, because when you're using the therapeutic model, obviously any offender is going to benefit from the approach in most instances. And by having a hard exclusion for some specific offenses, I think it unnecessarily narrows the scope of what you could do. The fact that you're starting with a therapeutic process does not necessarily constrain the end result. But in any event, that's we have to respect the funding model that's there, and I guess we deal with it as it arises now. We do an eligibility assessment of the individuals that apply to the court, and we're attempting to identify high-risk, high-need individuals, and that's based on the R&R model in terms of risk, need, responsivity. And we're looking for current drug use. If you haven't been using for 6 months or so, or a year actually, then we're excluding the person, because obviously the offenses are not necessarily linked. With the criminal behavior, we also look for someone with a significant criminal history. We have had situations where we do get some applicants that actually do not have sufficient need to warrant inclusion in the program, because it is designed for high risk, high need. In relation to the eligibility assessment, we're using an admission process which is a paper process. So the accused applies generally with the assistance of legal aid counsel or their own counsel. The Crown Attorney screens the offense for offense eligibility. The treatment team then assesses the person. We do a risk evaluation of suitability. They're using a couple of instruments to assess their suitability, the LSCMI and the DAST, and a couple of other instruments. That becomes important later on in the process, because we're using the scores on that to measure the person's progress throughout the process. The assessment that we do have has evolved over time, because we found that with the paper process, sometimes it's difficult for the Crown Attorney to make an assessment based solely on what appears within the four corners of the application. And so what we've done is we've elected, in some instances, the Crown Attorney may withhold their approval or rejection. And we move on to the risk assessment part of the process. And once that's completed, there's a team discussion in terms of whether or not the person could, in fact, qualify for the court. And what we're looking for is someone who's motivated to do the program, and also someone who we think we can work with and has the potential for success. So again, we're looking at trying to broaden our net in terms of accepting as many people as we can. The court process itself is similar to most therapeutic courts in the sense that you have an admission, a treatment, and a graduation process. With ours, it's a 4-stage. And the first part of the orientation stabilization, that's when the person enters the court process. And we do have, from a procedural point of view, a 60-day period where the person can withdraw their guilty plea and go back to the regular court process. And by the same token, if it's apparent within the first 60-day period that the person is unable to meet the requirements of the court or just isn't succeeding, then of course we can send them back to the regular court process. During the orientation stabilization process, the person is trying to develop a treatment plan, and the treatment plan is then worked in through the case management treatment aspect of the second stage. And they follow the treatment plan with the goal to address the needs that they have. And thirdly, we move into the maintenance and aftercare, which to me is perhaps one of the most important, or the most important part of the process. And that's where the person develops a go forward plan as to what they're going to do once they graduate from drug treatment court, to see if they've got some community supports. Have they got a relapse prevention strategy? Do they have family connections? Have they got proper housing? All of these things are with a go forward plan as to what they're going to do in the future. And the last part, of course, is the sentencing and graduation, which is the ultimate goal of the program. There's differences between the therapeutic courts, and I worked in all of them here, and I just thought I'd mention this. With the mental health court, the main difference is that more occurs outside of the courtroom, in the sense that, more occurs outside of all the courtrooms, but in mental health court, the number of court appearances is less important because frequently, depending on the diagnosis and challenges the person has, court appearances are not necessarily of benefit to them, and may actually impede their progress. So frequently you'll have persons who may appear only once or twice in the court, and the balance of the work is really done by the treatment team, who puts them in touch with the psychiatric help that they may need and other community supports. With family violence, the difference is chiefly, well, again, it's a therapeutic model, is there's a much larger role for the victims and families. Because it's predicated on the view that the person who's going through family violence is going to have an ongoing relationship with the others, usually. And there's often shared custody and or assets, and that, as a result, plays into that particular model. We use rewards and sanctions, as do all the drug treatment courts. And with respect to that, I would just note that with our sanctions, we use the traditional ones with additional court appearances, additional drug tests. We've also occasionally gone with written assignments. This is one that I find is useful in the sense that what it does is when the accused has had a problem with meeting a component of the program, if they then do a written assignment in terms of why they had that problem and discuss some strategies of how they can address it, it's a useful exercise in engaging the person in the process. The rewards, of course, are standard, and we're limited in what you can do. Coffee cards, grocery cards, week off court, things like that. Also, as they work through the process, court appearances become less frequent. And while looking at this from the outside, the rewards do seem sort of superficial, or in terms of being not that hugely significant. I just took a section out of a graduate statement on her graduation, and I think it it shows her insight into her understanding of how the process was working. And I thought it was good because what she said was earning rewards along the way felt like an accomplishment. When I when I earned the reward of coming to court less, I felt like I reached a major goal and it gave me confidence. Well, as I said, from the outside, when you look at that, it doesn't seem like a huge kind of reward. When they're going through a lengthy process like our drug treatment court is, these acknowledgments along the way go a long way to the person marking their progress. And so it is a useful tool and one that, I think is worthy of emphasis. This is just, I just included this as a reference point. This is what our treatment plans look like. And the advantage of the treatment plan is only this, and I know that everyone's familiar with this, but when you engage the person in the process, and they themselves are authors of the treatment plan or collaborators on the treatment plan, they're much more likely to be successful. Because when you've endorsed the process yourself and set your own goals, it makes it more attainable. And you'll see that it's quite a straightforward plan. You set out what the goals are, how you intend to reach the goals, how can drug treatment court help you attain those goals, and importantly, what are you going to know you've reached them? What's the outcome measure you're going to look at? So that's just an example of what we're using, and it's part of our it's part of our process, which we found to be helpful over the last number of years. We've developed one other aspect, and this is really coming from a court process point of view. We have what are known as continuation hearings, and this occurs when over time the applicant is not meeting the targets, and you reach a point where it looks like they're not succeeding. My concern was that as with most therapeutic courts, what we do is we have a meeting prior to court every week and discuss the progress of individuals and move on from there. And my concern was the process was becoming less transparent. And I thought it was important that the individual know these things and have a chance to properly address them in an open court setting so everybody knows what decisions are being made and why. So what we do with our continuation periods is there's a written report made by the treatment team, and the accused is given an opportunity to respond to it. So this is an example of one. And what you can see from the continuation report is that the treatment team has identified what happened. In this case, the accused had a relapse and went back into drug use and actually committed an offense. And we discussed it with him, and initial thinking was that he might be discharged and sent back to the regular court process. However, on working with him and with the continuation report at the hearing, it was evident that he wanted to continue, that he was dedicated in terms of moving forward. And what we did is we came up with a response in terms of he returned to weekly appearances because he was on biweekly at that point, and his participation was going to be reviewed weekly. And that was the agreement that we made. I think that this is sort of helpful in the sense that when you have this kind of adjustment, it's more in keeping with the recommendations from Volume 3 of the Mass Casualty Report in Nova Scotia in terms of the idea that therapy's got to be an ongoing process. And it doesn't make sense really if there's an opportunity to move forward that you abandon the effort at that stage. So this is one approach we've taken. Now, naturally enough, not everyone's going to succeed at the continuation level, but this is a process that we've added. Some of the issues and challenges that we have had with people that have been unsuccessful have been reoffending. Clearly, that's an issue. I have to admit that when we first started drug treatment in court, my initial approach was that if a person reoffended while under drug court undertaking, I didn't really see how they could continue. I've since softened on that issue. And in certain instances, if the offense that they have committed is one that was eligible for the court and can be included in their overall situation, then we've gone on to do that and included it, but it may result in the person being involved in the process for longer. Alcohol is a difficult issue. People tend to, on interview and being admitted, tend to underreport their alcohol use. And alcohol interferes with the other aspects of the programming. If it's an issue that becomes paramount in the sense that it's more significant than the drug use, we found that we haven't been able to work with a couple of applicants when that's been the issue. I don't know that what the appropriate response to that is, perhaps another therapeutic program, but it has been problematic with drug court. Mental health and concurrent disorders, what we've done in most instances with that, if the mental health court, if the mental health challenge is more significant, we refer them on to the mental health court, and the mental health court has recently taken up some drug testing, so they are able to partner with us on that. We have had some successful transfers doing that. Just on that point, this is perhaps an obvious one, and one that I like in terms of, this is from Niles Olberg, who is the director of the Swedish Correctional Program, and they did a survey of all the persons in custody in Sweden. And one of the issues that they identified is that naturally enough, when you're involved in therapeutic courts, you tend to be sort of one-trick ponies in the sense that you tend to focus on your issue. But actually, when you're dealing with people in these situations, of course, individuals that have been involved in the justice system and have these kind of high risk, high needs have more than one problem. And it's the job of the therapeutic court to try and address as many of them as you can to come up with the appropriate treatment response. So that's just something you have to be aware of. We have our graduation requirements. We require a minimum of 9 months with abstinence from identified illicit drugs, no new charges under the criminal code or CDSA. I have to have compliance with drug court conditions and a demonstrated change in the need areas as updated in the risk and addictions assessments. So that's where the LSCMI comes back in. I've just got a couple of slides there in relation to what a graduation looks like. And this particular individual came in and he was 21 months in our program. And you can see we used the LSCMI score. When he came in, he had a high score of 31, severe issues on the DAST. And at the assessment, he had work issues. He had little community support. He had limited family support. He had mostly negative peer. And he had the thing that he did have in his favor was he did have some housing and transportation. But he was certainly in a high risk, high need individual. When you look at the graduation outcome, you can see by using the same LSCMI instrument, he'd reduced his needs to 16, putting him down moderate. He had addressed issues and drug-related issues. He had peer interactions. He had family supports, and actually he'd started his own business. I have to say that this gentleman was a real success story for us. And he suffered a traumatic injury through his work when he first started the program. And I really thought that when that occurred, that would prove to be too big an obstacle to overcome, but he did overcome it. And he said, and this again is from his graduation statement, he said that this shows the insight that he developed. He said that he didn't think that he'd be able to succeed. A lot of my breaches in the past were because of missing appointments, but I also like to have someone to run things by and dealt with people who didn't judge me, which was important for him and really is in keeping with our therapeutic model. So I think that he's a reason that the courts have succeeded. And I think that a lot of the work is due to our treatment team, or all the work is due to our treatment team and his own efforts. And it's nice to have successes. Those are our numbers. I just did our numbers over the last 5 years. So we have had 90 90 applications. We've had 12 graduations, which is a huge achievement, I think. We have had 22 people that were unsuccessful at this stage, but I have to say that whenever someone undergoes the process and stays with the court for a number of months, irrespective of whether they ultimately succeed overall, they will have had an opportunity to address many of their issues, and you will see improvements overall in their overall lifestyle. So there is a benefit to the court process, irrespective of whether you ultimately reach the very high threshold that we improve for graduation. So those are just some of our raw data that we have for now. The other good news is that the funding has been secured for the next 5 years for the court, and we intend to expand to 3 more areas within the province over the next couple of years. So overall, it's a very positive experience that we've had. I like to thank you for inviting me to speak. I think I probably went through that fairly quickly, but I know that you've had a long day and you have lots of presenters. So,
in fact, Judge Orr, we let you go 10 minutes over the time because your presentation was so engaging that I just could not say no to you, Judge. It's amazing. So what we'll do is this, the time is 3:10. Let's take a quick stretch break, come back. But Judge Orr, from the bottom of my heart, thank you. That was amazing presentation. Thank you. So let's take a quick 5-minute stretch break, come back at 3:15. And then our next speaker is Associate Chief Judge Sue Wishart. Hopefully I'm pronouncing your name correctly. If not, I beg your forgiveness. So 5-minute break, let's come back. And thank you, Judge Orr. Thank you.
thank you. All right, let's do that. And go. No idea what. All right, do this.
All right. Okay. So the time is 3:15 right now. I think we are on the dot. Our next speaker, let me just briefly introduce our next speaker before we kind of get started. So again, sorry, give me 1 second. Let me just go to the proper page. Yeah, so Sue, can you tell me how's your last name pronounced? Because I want to make sure I want to.
No, you were correct. It's Wishart.
Oh, Wishart. All right, thank you. I'm just afraid. I just want to make sure that I'm pronouncing it correctly. So a bit of a brief introduction. So Sue Wishart resides in Victoria and has been a judge of the Provincial Court of BC since 2009. In May 2016, she was appointed Associate Chief Judge. As Associate Chief Judge, she serves on various committees, including Access to Justice Initiative, Court Technology, Family and Small Claims Rules Reforms. She is also involved in specialized courts across the province, including Indigenous and First Nations sentencing courts and sorry, the Aboriginal Family Healing Courts, Conference Child Protection Projects in New Westminster, drug treatment and downtown community courts in Vancouver, and the Victoria and Kelowna integrated courts. So yeah, take over.
Thank you very much. And although a lot of my responsibilities as an associate chief judge involve family and small claims, my background as a lawyer was as a criminal defense lawyer. And so I'm also very interested and involved in the therapeutic courts and Victoria Integrated Court in particular. I've sat as a judge in that court for about 18 months at one point. I call Victoria Integrated Court doing what we can with what we already have, because there are no additional resources or money associated with Victoria Integrated Court. And it was really started at the I guess it was an idea that came from the community on how do we deal with what was a high level of street crime and homelessness in Victoria, and how could the criminal justice system respond. And so in 2010, this court was created, and the basic idea is using services that already exist and using various community outreach teams that already existed and incorporating them into our court system. So there was no new court time added. We took existing court days. So for example, in Victoria, we have a criminal docket that's 5 days a week. We took Tuesday mornings and said any accused who is associated with one of these community outreach teams, we will deal with those people on Tuesday mornings. So the court has grown over the years and changed a bit, but I'll describe where we're at now in terms of this court. But the key features really are including the community outreach teams into the court process. So any client of integrated court, and we do call them clients, as many therapeutic courts do, they do have to be supported by an existing community outreach team. This may include, there are teams that are under the Ministry of Health, there are teams that are with Community Living BC, and most of those clients are people with brain injuries. We also have a few supportive housing agencies that have some wraparound services. So that is mandatory that somebody is attached to a team when they first appear in integrated court. They might not be connected yet, and there can be a process to see if they can be taken on by a team. And participation in this court is voluntary. So if somebody wants to go through the usual court, they're free to do so. This is a sentencing court. Some bail hearings occur in this court as well, but because it's only Tuesday mornings, obviously bail hearings need to happen at other times. but is mainly a sentencing court. And if there's somebody in integrated court who wishes to have a trial, they would be scheduled into a trial court the normal way. And when I describe this court, I refer to it as resource neutral-ish, because there is an additional workload for the prosecutor that is involved with this court, as well as the probation officer. And the integration of integrated court refers to really integrating information. So clients sign a consent form to share information amongst agencies, because we have health, we've got housing, we have the various other teams, we have resource providers, and they need to be able to share the information to effectively do the second part of the integration, which is integration of existing services. And because for a lot of the teams, their clients are vying for the same services, and by sharing information, we can better use those and better prioritize who is in the greatest need of an existing service. So the sharing of information is critical, and it really does lead to better outcomes in terms of using those services, better outcomes for the clients. And in my view, as a judge, you can make, excuse me, better orders on bail and sentencing, because you have so much more information than I would have in a typical court day. So the court team consists of these community outreach team members who come to court every Tuesday morning. There's a police team, so it's usually 2 officers who are assigned to integrated court, and they're able to flag clients within their system. So if they or another officer is dealing somebody who is an integrated court client, rather than breach them, they can reach out to a team member to see if there's another way of dealing with whatever brings them into contact with the police. There's a dedicated probation officer assigned to this court. We have defense counsel, and it's usually the same, I would say 10 defense counsel who are participating. They're not specifically assigned, but they tend to be defense counsel who deal with these clients. There is an assigned prosecutor, and there is an assigned judge. And having that consistency, as I'm sure everybody knows, is very important, because you actually develop a relationship with the clients. And that's very important from a therapeutic justice perspective. The information sharing works by having pre-court meetings. They used to occur on the court day earlier in the morning, but with the pandemic, they've switched to doing those virtually, and now do it a few days before the Tuesday morning. So everybody meets, not the client and not the judge, but all of the other team members meet. They share information about what's happening with the client. Are they waiting for a treatment bed? Do they have housing? How are they generally doing in the community? And then on the Tuesday mornings, everybody comes to court, and that information is shared with the judge. So it's usually the team member standing up and providing oral information about their client. And it's quite impressive to watch the team members do this, because they have to maintain the therapeutic relationship they have with the client, but at the same time, let everybody know how they're doing. And they're extraordinarily respectful of the people that they are assisting. And I think we're all careful in terms of how we are addressing the client, what we're saying, because we want to support people as much as we can, but also hold them accountable and maintain that therapeutic relationship that they have with their team member. So if somebody is on bail and hasn't been sentenced yet, we call these progress reports, where information is shared about how the individual is doing. The prosecutor may decide, if somebody's been doing well prior to being sentenced, that they're actually going to stay the charge if there's no longer public interest in proceeding with the prosecution. If it goes to the sentencing phase, again, as a judge, I'm provided with much better information about this individual. I have a discussion with that person so that they feel like they are part of the process and people aren't just speaking about them or at them. And I'm able to ask questions of the team members, and there are a lot of joint submissions, but in terms of a probation order, as a judge, I'm able to incorporate conditions that support the work that the team is doing. And this can be very basic conditions such as you will meet with your team member every day at 11 o'clock to get your medication. We can be very specific about what programs they're going to attend because we know what's already been set up. It's not a general counseling provision. It's this is where you're going to go. And that is much more effective from the team members' perspective because they have something else they can rely on. It's not just them working with the client. It's also, well, remember what the judge said, you also need to make sure you're doing what's on your probation order. If a client is sentenced to jail, and they are sometimes out of integrated court, we do pre-release planning. So the team members are meeting with the client in the jail to make sure that they have everything set up for their when they're released to be on their probation order. And we actually have a court appearance, usually a couple of weeks before they're going to be released, where we have a conversation with the individual, again, making sure everything's in place. We can tweak the conditions of the probation order if we now know a specific place they're going to live or program they're going to take. We can adjust the wording to be more specific, but trying to, as much as possible, set them up for success upon release from custody. And the other really cornerstone piece of integrated court is anybody who is on either a probation order or a conditional sentence order. After their sentence, they come back to court for reviews. These tend to be more frequent at the beginning. And then often it's left up to the team member to determine when somebody should come back to the court. But it's a very important process, part of the process. And I think for me as a judge, seeing somebody coming back who's doing well is not only very gratifying to me personally, but you can see in the client how proud they are to be able to come back to the court and talk about how they're doing. If somebody is struggling, we try to discuss as a team what else can be offered to this person, what changes can be made to the probation officer or to a probation order. And if the client knows they have to come back to court and they have to tell everybody that they haven't been doing that well, that is also a pretty powerful motivator for them. And we often see probation orders terminated earlier if people are doing really well. There have been a few evaluations of integrated court. We did one after the first year, and then there was another report done by some master's students at the University of Victoria looking at this. It's not all about recidivism. It's about other measurements of overall health and wellness. As a result of this court, we have seen a significant decrease in the number of police contacts that people are having in the community, a decrease in the number of hospital beds that people are using, and an increase in housing for these clients. We now have another integrated court in Kelowna that started 2 years ago. It's not easy to replicate across the province because the foundation is these outreach teams, and they don't exist everywhere. And we really have to have buy-in from the community as opposed to this being a court-driven initiative. But the early reports out of Kelowna is it's also making a significant difference in that community. Sometimes the difference is it highlights the gaps, and then other service providers step in, and that's been in Victoria. That was the housing piece was really challenging, and it's much better now. And I think the same is in Kelowna. So I wanted to make sure I've left time for any questions, but that's the no frills therapeutic court that's running out of Victoria and Kelowna.
So thank you, Associate Chief Judge Vishad. We have one hand up, so I think it's probably you have got your first initial, J. Dulude. If you wish to just jump in and unmute yourself, and please ask your question.
Actually, the question was for the previous speaker.
All right. Okay. My apologies there. I don't know if you could ask the same question of Associate Judge Vishad.
Perhaps. This is from Thunder Bay, Ontario. And we recently have just got funding to start drug treatment court here in Thunder Bay. So we went down to Toronto to see how they ran their model. Now, my understanding was that in drug treatment court, they're partial to accepting clientele who have illicit drug problems. However, the biggest problem here in this city for the clientele that we're likely to receive has to do with more with an alcohol use disorder rather than illicit drug use. I'm just wondering what your thoughts would be on that.
Yeah, I think that we as a justice system need to look more broadly at these issues, because that's one of the things that I'm approached about is we need a mental health court. We need, an alcohol addictions court. And most of the people that we see often, as I'm sure everybody knows, have more than one of these underlying issues. But I agree with your point that for a drug treatment court, there's a whole sector of people who are in the criminal justice system who aren't getting the access to the same type of services. And I think that there's certainly momentum, at least of thought in terms of how do we help more people, and should there be treatment courts that are geared towards alcohol as the substance use. I think that would make a significant difference in a lot of communities. Just speaking as criminal defense counsel formerly and as a judge, 70% of the things that come before court are alcohol related, whether it's mischief, property damage, interpersonal violence, assaults in downtown after the bars close. Alcohol is the underlying factor of so many of these things. So I think it's another area that is hopefully we're at the right moment in time when some effort can be put into addressing that. As all of these things come down to, though, it's usually a funding issue, and that's a political decision as in terms of where people's priorities lie. But you're quite correct. There is a disparity in terms of which populations are getting the available assistance.
Yeah. Any other thoughts, questions, anybody? And Associate Judge Abhishek, I think also this is just, I'm coming from a social work perspective. I'm a social worker by training. And so my personal belief is that people feel in our kind of society, modern industrialized society, people feel like atoms, like floating in the air and without any connections and without any attachment. And my interpretation of what you just said is that I think this is a wonderful way to connect people, right? People who are feeling lost in this big wide world, and connecting them to services, connecting them to treatment, connecting them to other fellow human being. I think and kind of that's the role that I think you're taking. I'm not sure what's your take on this, but this is just my theory here.
Yeah, and one of the other really neat parts of Victoria Integrated Court, this was a colleague of mine who's now retired, worked with a number of nonprofit organizations to start a community garden. And this is somewhere where we were able to have clients go to do community work service. And when they're finished their community work service, if they wish, they can stay on and work, and they share in the profits from that garden. And for some of the clients, they say it's the first time they've ever felt part of anything. And they're working alongside the probation officer will show up and spend a couple hours there. Judges show up and do a couple of hours in the garden. And so it really does, I think, highlight what you've just spoken about making people feel that they're part of something. And because often in court, things are just by the nature of the volume, things go very quickly. We don't have time to make it as personal as we should and treat people the way that I would like to be able to in a very busy court list. So I think that's a really important part of these sort of courts is finding ways to be creative to make people feel that they have a sense of community and a sense of belonging.
Yeah, thank you, Associate Chief Judge Wishart. Thank you, amazing. I don't know, I just feel really nice and warm that our courts are almost I don't know what lack of better word, humanizing and kind of treating others as humans. So thank you for this wonderful presentation, and thank you for caring persons like yourself who's there in the trenches and kind of are there connecting people and connecting people who are there in these the justice system. So thank you.
Well, my pleasure. Thank you for inviting me today. And I know you're going to hear from Sharon Lockhart about the Vancouver Downtown Community Courts, and she'll let you know all the amazing things you can do when you do have money.
Thank you. So thank you. We have our next speaker, JC Allen. Hopefully I'm pronouncing your name correctly. And so JC, take over.
Can you see me and hear me?
Yeah, we can see you and hear you. Thank you.
Okay, let me see if I can bring up my presentation. Bear with me. Share. All right. Is that coming up? Because I don't think I'm seeing, are you getting the proper?
Yes, we can see everything, the PowerPoint, we can see you, we can hear you.
All right, it's go time. Well, thanks so much for having me. You did pronounce my name correctly. It is JC Allen. I am the current Drug Treatment Court of Vancouver Crown Counsel. This is my third time in this role. I came back to this role last September. And I'll start, my presentation is going to deviate a little bit. I took the assignment down a different path, I think, than most. I'll start with an overview of our program. And having just listened to Judge Orr's presentation, our program is very, very similar. And I think a lot of the DTCs are. So I'm not going to get into the nitty gritty. I'll just say that we are both federally and provincially funded, and the requirements of that federal funding give us certain parameters within which we have to work. We require guilty plea, no violence. Jurisdictionally, we cover the whole province, but the treatment center is located in Vancouver, and at present, we do require participants to relocate to Vancouver. We don't have the capacity to offer the treatment program remotely. It's a 4-phase program that requires, in the beginning, daily attendance at our treatment center, and then that contact diminishes over time. It's a minimum of 14 months, and it takes, on average, between about 18 months to 2 years. And then all graduates receive the same sentence, which is a suspended sentence with 1 day of probation, no conditions. So we're very fortunate. We have 5 agencies at the table in our program. The court team is, of course, comprised of a dedicated judge and 1 backup judge. 1 full-time Crown, that's me. I'm with the PPSC. We do accept provincial charges. We simply take conduct of those. And we have a dedicated legal aid lawyer for all our participants. Our case management is provided by BC Corrections probation officers, and they work very closely with our health services provider, which is Vancouver Coastal Health. And Vancouver Coastal employs addictions counselors. They have a medical doctor who specializes in addictions medicine, and a nurse practitioner. We are very fortunate to have a large outpatient facility that houses the entire probation and treatment team. And in there's a number of rooms where counselors can run groups, conduct one-to-one therapy. They'll even host extracurricular events like drum circles, which are a lot of fun. And they'll celebrate various events for the participants. They also do the witness urine screens on site. So, I guess I should have gone to that first. There's all our agencies. So I want to talk about the current landscape, because our program, like many other programs, are facing a lot of external challenges. And what we're doing isn't working anymore. because the people we're serving are different, or they're not coming to us in the same numbers they were before. And that's by no means a criticism of the work we've done so far, but we now have so much more evidence and information about addictions than when this program started in 2002. The Drug Treatment Court of Vancouver was the second in the country behind only Toronto. And at one point we were the largest, not anymore. But we have so much more understanding and information available to us to inform how we handle our participants. So I chose to focus my presentation on identifying some of these challenges we're facing, put some ideas forward to explore possible ways to address these. These are by no means the only ways. And I really want to invite anybody watching this to think about some of these alternatives. I think we should look to some other fields of study to find ways to further support our clients, maybe add some new supports. I'll give some examples later, and to augment the program's best practices that we're already employing. So the biggest challenge for us, and again, probably many programs, is diminishing enrollment. And in BC, we have a rather unique perfect storm of factors that are contributing to our low numbers. The changing political and legal landscapes have contributed to reducing the appeal of what was once the only way someone had of getting around the mandatory minimum jail sentences for PPT and trafficking involving fentanyl. So I don't know how well known the Ellis decision is outside of BC, but it's a BC Court of Appeal decision just from last summer. It's out of, well, the provincial judgment was out of Campbell River, and Tanya Ellis was initially sentenced to a suspended sentence with 12 months of probation. The decision was successfully appealed by the Crown to the Court of Appeal, but it still resulted in a non-custodial sentence. The Court of Appeal imposed a new sentence, extended Tanya's sentence to 3 years of probation with more strict conditions, but it really propped open the door to non-custodial sentences and encouraged courts to place considerable emphasis on the personal characteristics and circumstances of substance users who commit crime in order to access their needed drug. So the second factor is we have some other therapeutic courts in BC, which is a wonderful thing. But of course, they compete with us for our participants. We have First Nations Court and also the Downtown Community Court, which you will hear about from Sharon Lockhart right after my presentation. And those courts offer intensive wraparound programs that really support their participants to healthier lifestyles. There's also a PPSC pilot project that decriminalizes 2.5 grams of hard drugs. And that, of course, has resulted in fewer charges that would have qualified for our program even being approved. And it's already been a few years since the PPSC charged simple possession, but some of the quantities that are caught by this new initiative, excuse me, of say 2.5 grams might have resulted in PPT charges if it's a particularly potent drug. And lastly, we have new initiatives in restorative justice and alternative measures, where some of the files that would have been referred to us are going through those processes. So if we are going to appeal to applicants, we have to change what we have to offer. There's no drug treatment court without participants. And if we're going to attract them, we have to offer them something they can't get elsewhere. And I would say the focus is on two things. First, we have to offer an appealing sentence alternative or bail pending sentence, an appealing program to what they can get in regular court. And second, if they are going to come into our drug treatment court program, we have to offer them a real chance of success. So what do we define as success in drug treatment court? And I think with all the changes that are happening around our programs, there's a really disconcerting state of flux and uncertainty. But there's also an opportunity to re-examine the components of our programs, keep what works and jettison what doesn't. So what I hope to do is share with you some of our challenges and offer up some ideas to stimulate your thinking and encourage discussion of the therapeutic courts in our country. So I came up with 3 possible options. What are some things we can do to affect a different result? Can we improve our screening processes? Can we really stay true to an evidence-based approach versus an ideological one? And the hardest question, can we improve contingency management? So like other drug treatment courts, the screening process is very similar. The Crown focuses on what is the offense and the criminal history. Corrections focuses on whether the person can be safely supervised in the community, and the health partner focuses on whether or not there's a current active addiction. Those are the screening criteria. How can we do it a bit differently? Well, as a Crown, I know that our office is starting to consider on a case-by-case basis more serious offenses. What we're finding is that as we get more sophisticated and the criminal justice system does, so do offenders. And so what we're finding now is the people we want to target, the unsophisticated offenders who have serious drug addictions, are now being recruited by sophisticated predatory criminals into situations that put them in a lot of legal jeopardy. We're finding people carrying large amounts of drugs on them or being found in meth labs that have weapons and lots of money and lots of drugs in them. Offenses that would normally attract that understanding that they are doing this for commercial profit, and that would normally put them outside of the eligibility criteria for our program. Secondly, corrections or probation can hopefully refine tools to be able to better predict who is a safety risk for the treatment team. I think sometimes using the criminal history and saying there's a violent offense on there might not be the most accurate tool. And thirdly, if we can expand our screening criteria from the health perspective, so that we don't end up with people who've gamed the system by simply giving the right answers during their treatment interview. Again, I don't have all the answers. This is just to stimulate thought and conversation. So this is just more of what I was just talking about. Evidence versus ideology. I know that all of the programs that drug treatment courts and other therapeutic courts employ are evidence-based. But is that enough? We take pride in that, but are we collecting and analyzing our own data along the way to ensure we're achieving the results that the evidence-based program did? And can we assure ourselves that treatment and court directives are having the desired outcomes on a day-to-day basis? How do we know? What data points do we collect? How do we analyze it? And what do we do with it? So I want to stress the importance of data in tailoring treatment to the individual for the greatest possible effectiveness. There's no point in calling an approach evidence-based if you're not taking the same kinds of data that the study that produced the evidence did, and which demonstrates you're getting the same results. We need to track fidelity to the evidence-based model we're adopting, as well as the effects it's having on participants. Data collection on all points of intervention is key to customizing treatment. And we have to regularly review that data so that we can be agile in choosing next steps for our participants. If we have a recommendation to impose a sanction for, say, a missed group during the week, there should be a hypothesis that accompanies that recommendation. In its simplest form, the theory is that imposing a punishment on a participant will change their behavior in a specific way in the future. Practically said, if the participant is assigned an essay on the importance of attending group therapy, and the intention is that this contingency will result in improved attendance in future, then tracking that is necessary. And failure to do so is not only a lost opportunity to maximize treatment, it's also evidence that the program is ideological, and the failure of a participant to behave in accordance with that ideology results in punishment that doesn't serve any practical purpose other than to further ingrain that the locus of power is not with that participant. So data science is no easy field. I don't suggest that we try to come up with this ourselves within programs, lawyers, counselors. We need comprehensive metrics that demonstrate what we're doing is working. I know my level of understanding of data analytics is rudimentary at best, but there are people out there who do this professionally. And my suggestion is to recruit academics and professionals who appreciate the significance of data in steering a program towards success and who have the expertise to design functional tools. What comes to my mind is looking to the field of behavior science. They can help case management professionals customize programming and evaluate day-to-day impact of both court and therapeutic measures. So all members of the drug treatment court team participate in behavioral procedures intended to steer participants towards healthier lifestyles and pro-social habits. Our programs provide counseling, group therapy, education, opportunities for peer support, sometimes recreation and fun. But the most notorious procedure, the one the court program is most known for, is contingency management. So drug treatment courts operate on the rudimentary principles of behavior modification, reinforcement, and punishment. And criminal courts have historically been in the business of the latter. More recently, therapeutic courts have seen benefits and improved outcomes associated with adopting contingency management procedures using both consequences. And there's a lot of room for exploration of reinforcement over punishment. Sanctions are familiar territory, but we know the evidence demonstrates these are far less effective at facilitating behavior change than rewards are. The temptation to rely on the court as the enforcer is strong, but we have an opportunity to leverage our relationships with participants to incentivize pro-social behavior. There's also a cost to favoring punishment over reinforcement. Damaged therapeutic relationships, furthering participant trauma, and entrenching shame, none of which are likely to lead to our goals. As I said earlier, if a proposed sanction isn't accompanied by a hypothesis that attaches to an outcome, then we are simply exerting power over the powerless. At worst, it demoralizes a participant, contributes to a critical self-perception, and derails their progress. At best, it may contribute to their compliance with program expectations and maybe even contribute to the ultimate goal of graduation. If the sanction results in the former, we should stop doing it. In the latter, then we need to examine why closely so we can use that tool deliberately and with precision. How am I doing for time? Okay. So one of the other things I want to bring up is that all of our participants are not equal. We all know this. But one of the things that has become clear to me is that there's a real variation in executive functioning. So we view participants as autonomous adults with a choice to comply or not comply. Failure to comply is defiant, and we implement something corrective. We also say that in the name of accountability, we have to justify punishment sometimes. But there are clients who don't have that choice. What's being asked of them is simply beyond their executive functioning ability. It's important to note that we have a lot of undiagnosed neurological conditions in our population: autism, ADHD, brain injury, trauma. Their motivation is different, and our treatment should account for it. One of the tools that we use in behavior analysis is something called a task analysis. It's where we can teach somebody how to do something. It's an adjunct to an addiction treatment that might support success. And I'll give you an example. So this might be two different clients, and the task is that we want them to attend group. So for the more sophisticated client on the left, it's a simple 7-step procedure. For somebody who's got a lower executive functioning ability, it might be a 16-step or more procedure. And for someone to sit down with them and to write this out and go over it with them and teach them would probably improve their chances of attending group. So I've blasted through a lot of information. I hope I've stimulated some thought, and I'm happy to continue a discussion on any of these things or more. But I do think there's hope for the future of our programs. I know it's a challenging time, but I believe we're up to the task of adapting.
Yeah, wow. JC, thank you. What we could do is get Sharon on board and let Sharon complete her presentation, and then see if there are questions. Hopefully you will hang around a little bit for about 10-15 minutes, and then see if there are questions. We could just take them up at that point of time.
Of course.
All right. Okay. Thank you, JC. So let me introduce Sharon to you. Sharon is our last speaker for today. So Sharon, for the past 35 years, Sharon Lockhart has worked with the local communities, nonprofit, government agencies, courts, stakeholders, indigenous communities, and community partners to build relationship and help those involved in the criminal justice system transition successfully back into the community. Sharon is the director of the integrated programs with the Ministry of Public Safety and Solicitor General for Downtown Community Court, the drug treatment court of the Vancouver DTCV and the Vancouver Integrated Supervision Unit. She is a board member of the Canadian Association of Drug Treatment Court Professionals and an active member of the Restoration Collective of the Vancouver Piece of the Circle, and the vice president of the Soroptimist, sorry if I'm mispronouncing that, okay, International and North and West Vancouver. So Sharon, please take over. Thank you.
Okay, thank you very much. I'm not sure I can still see JC's screen.
Oh,
so...
yeah, JC, maybe if you can stop sharing.
Oh,
you're trying
okay,
to figure that out? Okay. So what we could do is this, let me just quickly share this and stop to share, and then hopefully that will disappear. Oh, no, it did not. So Sharon, JC,
go out and come back in.
Yeah, you might have to stop
Thanks,
sharing
JC.
your screen, and then let me just see if I can do anything at my end here. They've given me the powers, but let me see how I can use them or not use them. I don't know. So JC, do you have the, all right, there we go. Thank you.
Oh, there we go. Okay,
all
good.
right, Sharon.
All right. Okay, yeah, thank you. Let me just see if I can actually share my screen so that I can know that it's working before I start talking. Now I'm trying to share a PowerPoint. It says OneDrive Government. I don't know if this is the right way to do it or not.
Yeah, what do is open the PowerPoint presentation first, yeah, Sharon, and then do the sharing.
Yeah, so the share, let's see if this is gonna work. You let me me know when you can see it's doing something.
Totally.
I'm not sure what it's doing, but it's doing something. Should just be able to share my screen, but it's going right to the cloud.
Oh, it's going to the cloud. Download it onto your computer.
It is on my computer. That's what's so strange. Give me 2 secs here.
Yeah, take your time.
Share link to the slide. Why?
Oh, okay. Something coming up? No.
Okay, is something coming up?
No.
I have 2 screens, so I can see mine on my end, but for whatever reason, I wonder what if I, hold on, what if I move this over here, can everybody see it or no?
No. If you
No.
have two screens, maybe it's on the other screen. You might be sharing the wrong one, right? If you've got two screens, bring
Yeah,
it to the screen where you have the Zoom, and then share it via that.
okay, let me do that. Sorry, everyone. I
That's
got this
fine. I
all
mean,
ready to go. I was so excited. Hold on. Okay, let me just open the PowerPoint here and see if this will work. I don't want to waste time if anybody wants to ask JC questions or whatever. I think she's waiting.
yeah, maybe, yeah.
Stuck on.
Anybody wants to ask any questions? JC, there was one question I noticed in the chat. Maybe, I think maybe the previous, I'm not even sure because I've been trying to multitask and do too many things. This question, I don't know if you can answer this one, JC, is the question is, are random urine screen witnessed? And if so, by whom? Any idea,
Yes,
JC?
yes, for us, they are witnessed by a member of the treatment team. I'm not sure, but one of the counselors. Sharon, you probably know the answer to this too, actually. Yeah, it's done discreetly in private washrooms, but it is witnessed at the center.
All right, so hopefully that answers that particular question. Yeah. Or the other way, I don't know, Sharon, I can drop in my email. You can email it to me while you speak. I can bring it up for you.
Yeah, I can try. I'm just going to see if I can share one more time. It's only giving me the option to share from the OneDrive, even though I have it saved on mine.
I see.
So,
okay.
Okay. What?
Okay.
Sorry,
So
technical issues.
that's fine. Just my first name, my last name. Email it to me, and you can begin talking. As soon as I receive it, I will project it for you. Email it to that email. My first name dot my last name at uhn.ca.
Okay. A-B.
D-U-L.
Huh?
Yeah. Dot Gilzey. G-I.
At what?
At uhn.ca. University
UH.
Health Network.
.ca.
Yeah.
Okay. Let me
So
try that.
email it, and you can begin talking immediately after you email it to me, and
Okay.
I'll look for your email, and as soon as I get it, I'll let you know.
Okay. Maybe someone else wants to answer a question, and I'll do this right now. Sorry.
Yeah. Yeah. Meanwhile, you can. So thanks to everyone for your patience, and thank you for holding on. Thank you for still being here. We are 49 of us, and that speaks to commitment. It's almost not almost, but it is 4 o'clock, and you've been here since 9 o'clock. I want to commend you and thank you, and yeah, hang in there. We'll resolve this issue, no problems, and get this last presentation going.
Okay, Abdul, I've sent it to
All
you.
right. Okay. All right. So Sharon, you can start talking. I'll wait for the email. As soon as I get it, I'll let you know.
Okay, sure, no problem. Thanks. Let me just put this and pull this back up. Okay. So thank you, everyone, and I'm sorry I'm having technical issues. I am Sharon Lockhart. As mentioned, I'm the Director of Integrated Programs with the Downtown Community Court. I also am responsible for programs with the Drug Treatment Court of Vancouver and the Vancouver Integrated Supervision Unit. I've been involved in many of the courts from the drug court up since 2013 in terms of specialization. And I'd like to start off with a land acknowledgement. I am a third-generation settler on the traditional territories of the Coast Salish peoples here in BC, the Musqueam, Squamish, and Tsleil-Waututh. And I'm very grateful for the land that I'm on and the Indigenous people that have held stewardship over for many, many years. So thank you. And I'm going to start out with just a very quick overview of what DCC is. I recognize I'm last on the list, and it sounds like it's been a long and very interesting day. Yeah, have you had any luck?
No, not yet. I'm still waiting. Abdul.gilzey@uhn.ca. So
yeah, we
should
seem
be
to
coming. Sometimes it takes a bit of time.
Yeah. I wonder, I've got one more trick up my sleeve.
Yeah, you can check once again. I mean, this is the last presentation, so if those who have to leave can leave, no problem. But even if you're late by a few minutes, I think we're okay.
Okay.
I mean, this is beyond our control, so.
Yeah, I know, but it's hard because it's hard for people to kind of see.
For
you know.
sure.
Yeah, okay. I've got one other thing I did was I also have a copy on Canva. I don't know if I can share with you on Canva, so I will try that one last
Yeah,
time.
try that. Yeah.
Okay.
I'm just waiting. I still don't have it.
Let me try sending it to you that way. Sorry, we are agonizingly slow here at this end. I don't know why. Okay.
Yeah. Sharon, this is like some movie story, right? The 30 seconds look like 2 hours, right? Everything is going in slow motion kind of thing.
Yeah. Okay, I'm going to download share.
That is strange. Should have come in by now.
Yeah, I don't understand what's going on. We lost our whole TELUS down here last week, so I wonder if I try to share with you via email.
Or you know what? If you want to post the link in the chat, if you have it somewhere, right? If you can post the link in the chat, I can pick that and then project it there from my end.
Okay.
That is strange. This should have
Very
been
strange.
here by now.
And I've done this a few times before. We also did a test run with Justice Barnes and I've done them before on this site. So I'm kind of disappointed because it's I'm bummed out that you're not getting it. Okay. Alrighty. Yeah, that's not working.
See if you can post the link to that chat. You said a link to that. You said you have it posted. Yeah. Yeah. Post the link there.
But it's I don't know if you'll be able to get it or not.
Yeah, I don't know. So that is strange. Maybe my email seems to be working fine because I just did get a few emails and I just got one 5 minutes ago.
Okay, let me
but
try
not yours. So something might be happening somewhere.
Thank you everybody for your patience. I don't know if you're going to be able to get into that, but I'll do this again. abul.gilzay at uhn.ca.
Yeah, uhn.ca. University Health Network. So
okay,
my email seems to be fine.
Okay, if not, I'll just
I can give you one other email. You can try that. Try University of Windsor. These are all the universities I'm teaching. Same thing, first name, last name at UWindsor, University of Windsor.ca. UWindsor. Try that. Oh, I got it. I got something from you.
Okay.
1 second. Let me just see. I think it's that Canvas link I got. Let me just see if I can click on it and get that. So maybe the email might be very heavy or something, something. Okay, so let me see if I can open it with my Google account. It says Google. Hopefully it will let me in. Request access. Okay, so I have request access. I think it's probably password protected, of course. Right, your request has been sent. Check your email if you got my request for access. And yeah, maybe it's a large PowerPoint slide.
I think that's probably what that's probably what the challenge is. So
yeah, and I got the link, no problem. You have my University of Windsor account. You want to send it to me there? I'm monitoring that.
This one. Okay, here we go. Has requested access.
Oh, I think yeah. Okay, so you give me. Yeah, I just got one more.
Settings. I hope
let me see. Okay, so 1 second. Here we go.
I promise you it'll be worth it just for the pictures.
Yeah, all right. Let me see. You gave me the access. Let me see if I can go back and
it's circling. Got you in there. Send.
Okay. Lockhart. So Sharon. And I'm just going to click there. You've given me the access. No, it still gives me that message saying, okay, so let me share this with you, Sharon, so then we know exactly we are on the same page. So this is what I'm seeing, Sharon. Here, when I click on the link, when I click on request access, it says your request has been sent. So did you receive anything?
I've received it. I've accepted.
You okay? So now go back to Canva. Let me see if I can go back. Hey,
what?
This
Something
seems
there?
like something happening. Wait.
Yes.
Okay, hurry up. Okay, no, I don't want this. I can skip this.
Oh,
Is
okay.
this the one? Are we here?
It's Canva, but it looks like you have access to my account. So under projects, if you click
Okay.
on
Projects. Where can I
no,
see?
on the left, the tab on the left
there.
under home
Projects. Okay.
Yeah.
Yeah.
And then
Which
you will
one?
see, just wait, it hasn't come up yet.
Uploads.
It hasn't-
Purchased.
Just, I think you have to accept the cookie.
Okay. Oh yeah, let me accept. Create design, upload.
Try upload.
Start.
It should be right there.
It should be right here under project. Let me go back. So here I am, projects. Purchased, starred, upload.
None of
Start.
my projects are there. I don't think it's there.
No, it's not here.
Okay, let's just carry on because I know everyone's been waiting.
Okay.
I'm so
All
sorry.
right. Okay.
I apologize. I don't know how else to get it to you. So I'm just going to start out by talking about Downtown Community Court and what it is. Then I'm going to talk about what makes it unique and how it works and what the impacts on the community are. And I'm sorry I don't have these photos to share with you. The first thing I'd like to start off with is the Downtown Community Court is a problem-solving court that aims to provide earlier, fair resolution to criminal cases, benefiting offenders, victims, and the wider community. Downtown Community Court opened in 2008, and it is located right in the heart of what is called the downtown east side of Vancouver. It's the poorest postal code in Canada, and it is an area that we have a lot of low-income housing, single-room occupancy hotels. The hotels back in the day were actually put in place for tradespeople, foresters, fishers to stay for short-term accommodations, and they just morphed into what is now some very sad housing for people in the area. We work with community partners and stakeholders to improve public safety and engage social services, health, and justice workers together to address underlying problems that are associated with crime. So addressing the needs that people have to lower their risk and then improve their outcome. The Downtown Community Court is a geographically
All right.
based.
I got it. Okay, here is this the one? Just keep telling me. Tell me when to do what.
Yes.
All
Perfect.
right, here we go.
Sure. Thank you so much, Abdul. I appreciate your efforts.
No,
okay.
anytime.
Okay, so next one. For some reason, there's a speech bar in there.
Don't worry about that.
Okay, all right.
It will disappear.
Okay, so the Downtown Community Court, as I mentioned, is geographically based on, I don't know if everyone's seen that black bar across the pictures, but if not, the one on the left is the location of the Downtown Community Court. The one on the right is the inside of the community court, which is designed more like a family court. The judges, you'll notice the bench is lower. The client actually goes right up to the bench with the judge and talks to the judge when they sign their orders or when they, just to make sure that they're understanding the conditions. And the middle shot is just a recent shot from one of our many de-encampments in Vancouver because of our lack of housing. And I mention that because that is critical to the Downtown Community Court with respect to the housing and how we, with respect to how we support people. Next slide. So what makes Downtown Community Court unique is all of the partnerships that we have. So we have integrated case management teams that are made up of justice, health, social services staff under the umbrella of the provincial court, working collaboratively together, co-located under one roof. So we're all in the same location. I couldn't get all of our partners and pictures of things in there that I wanted, but it gives you an idea of kind of, this is sort of the what's underneath the umbrella. And the ability that we have of to share information on site, to be able to access rather than in a normal court process where you might have to stand something down for a period of time or put it over to the next week. Because the staff and all of the case management teams and the lawyers and the defense and everyone are here under one roof, they just go upstairs or downstairs to the court, which is on the lower level, and they can get those answers, provide the court and the judge with the information that's needed to help support the client. So it's a very, it's a pretty amazing, there's many programs in there. I'm not going to mention them all because I know we're running out of time, but we have in addition to the case management teams, we have a mental health bail program. We have a chronic offender management enforcement team. We have alternative measures. We have Indigenous alternative measures that with healing plans. We have legal aid on site. I could go on and on. We have a whole host of medical professionals, registered nurse, psych nurse. We have 2 psychiatrists on our team. We have a forensic psychiatric nurse, and we have addiction outreach staff. We have system negotiators with Watari, with a nonprofit, who help with lived experience, which makes a huge difference in connecting with clients. So yeah, that's pretty much us in terms of how the whole thing kind of meshes together. We are led by we have a management committee that meets every month. We have a steering committee that usually meets quarterly or 5 times a year. We have a community advisory council that where appointments are made through the chief judge and associate chief judge Wishart, and those people feed information to the court committee so that we stay in touch with what's going on, and to the extent that the court can help through programs on site and in the community, that we stay in touch with what that is, and we try to adapt programs for our clients here and bridge them into the community. The connections is a big piece. Judge Wishart mentioned some of the community garden initiative in Victoria for clients, and we try to do something similar here with our programs, so that if someone comes here to take something, whether it's music or art therapy, or they're learning about writing or whatever it is, it's something that's transferable to them in a meaningful way on the community. Because if it isn't, and it's just a direction from the court, it isn't going to stick, and the person's not going to seek it out, right? So that's an important piece of that. You can do the next slide. I better keep pressing through. I don't know how much time I have, but if you go on. How the community court works is a little bit of what I've already mentioned in terms of the umbrella and the partnership, because we're all under one roof. I've mentioned the steering committee. We also have an executive board committee, and the evidence practices that guide us in downtown community court are really about trying to figure out what's going on with the client that keeps bringing them back into the cycle of offending, and how can we change that outcome. So similar to kind of what JC mentioned about drug treatment court, we're trying to do something that helps the clients really get connected in areas that will make a lasting change for them. And the downtown community court, because of the location, because of the type of clients and it's geographical, we often have people in the programs that are low barrier. So they have more challenges, they have more mental health, they're more complex to deal with, they have addiction. We have constantly people doing wound care here, because the 2016 BC provincial health announced a public health emergency because of the opioid crisis. That hasn't stopped all through COVID, and we've lost so much housing that people are much worse than they were even prior to COVID. So it's the people, really. So I'm going to just fast forward maybe to the next slide, I think, unless I mix them up. That's the one. So what is all this? We all know kind of how courts work and what we do here, and we've got case management teams, and we're all under one roof, and it's an amazing way to get information quickly, both to the court, to the judge, but also for the client, and to set up a plan. But what is the impact on the community for a community court? A downtown community court, as I mentioned, it was opened in 2008. It's the first community court of its kind in Canada. It was modeled by the community court in Red Hook, Brooklyn, and it is not. It is grown into its own unique community court. So part of what we know works in terms of the connection to the community is what we hear from the clients themselves, which is why I have stories in the middle. The stories that people tell us, the actions that they have. So you have someone who's been traumatized, who's been living on the street, and they come on a regular basis, say to the art drop-in once a week, and they tell the facilitators that they feel safe and they're willing to talk to somebody. Maybe it takes 6 weeks, maybe it takes 3 months or longer, but then they're willing to talk to someone because they built that trust, and that trust takes time. You can't fast track people through that. And the access that we have here for mental health supports, I mentioned the psychiatrist and the psychiatric team, the mental health team, all of those people work together, peer support, all of that outreach within the context of integrated collaboration to have positive outcome for the clients, and it works. And I don't know what else I can say in the time I have remaining. I know probably everyone's ready to exit, so I don't want to keep too long. But if you just want to flip to the last slide for me really quickly. We've had some research done in the Downtown Community Court, but I'm just going to reference this is the most recent research we had. Dr. Reggie Garcia and her team then at UBC in 2019 put out this report, which you can get online for free. And it was a report that was actually profiled on the Downtown Community Court, observationally showing what the Downtown Community Court does and how it is impacting the social determinants of health, and how it's also connected to Canada's commitment to the United Nations Sustainable Development Goals for the Agenda in 2030, specifically Sustainable Goal number 3, which is health and wellness. And so what we do here that really we haven't really figured out how to measure properly is we're making a difference in people's lives from a health perspective, a social perspective, as well as lowering the recidivism, but that has a ripple effect to all of our partners. And that's what's not being measured. So for an example, if we have someone who's chronically offending, who's living on the street, who's got all kinds of health challenges, maybe some mental health, and they get connected with a team and they start to stabilize, they're no longer going to the emergency room visit every weekend. The police aren't being called, all of those things. So that's why I just wanted to mention this. And there is a follow-up report to this report, a part 2, if you will, that's coming out later this late summer. I believe it should be finished. It was a little bit held up because of COVID, but it's a part 2. And in that report, they've asked the judiciary, the lawyers, the judges, the Crown, defense, all the people working within the court of DCC, why it works, what their feedback, what the challenges, and what the positive pieces of the Downtown Community Court are from their side. So I'm really looking forward to that report, which will be shared as soon as it's ready. So that's a quick version of me, and I apologize again for the technical delays, and I'm happy to take any questions if there's time, or people can email me. There's one more slide that's got my email on it, Abdul, and I'm happy to answer any questions.
Let me quickly check. Give me 1 second. Let me see if there are any questions. Because sometimes it's right at the bottom. Okay. Okay. No, I don't see any question. Anybody wants to ask anything, please use the raise hand feature. I guess, Sharon, this is our core group, right? Our core group is the one that has been here since morning 9 o'clock to now. So amazing
Yeah,
group, but
amazing.
yeah, but Sharon, I think your presentation brought us full circle. We began with trauma. We began with social determinants of health and how those are important, and we've come back full circle in that sense of you brought us back to the social determinants of health and how those are important. Connection, stories, checking out our expertise a little bit, and kind of also incorporating our client's perspective into what we do. And those are important because without our client's involvement, this whole thing is going to fall flat on its face. It's not going to work. And so you brought us full circle in that sense of, that these stories are important, and that they need to be incorporated in any kind of treatment, in any kind of, even in the as impersonal institutions as our court, we still need to bring these personal stories, and we need to bring these in. So I don't know, Sharon, any last comment, anything you would like to say before we?
No, I'm sorry I missed the earlier presenters, and I think that what you guys have put together here is amazing, because each court, each organization, each agency has something that contributes, and we have to look at doing things a little differently within the context of what we can do. And no, I just appreciate the opportunity to share, and thank you.
All right, so thank you, Sharon. Thank you. Despite, I think, the technical difficulties, I think we got the gist of the services and the wonderful work that your organization and your agency, the program is doing. So thank you, Sharon, for sharing your wisdom, your thoughts, and we are very grateful to you. So I'm going to hold back or stay back for those who have any questions, anything for the rest of you. I think we'll kind of end this session. The time is 4:25. Unless somebody has any last minute comment, anybody wants to say something? Okay, I take it no. I think we are a tired bunch. Let's just all, log off and take a walk or do something different. Thank you, thank you, thank you to everybody. I'll stay behind, and the rest of you have yourselves a nice evening. And see you tomorrow.